May please. My lord, this matter may come up for orders, my lord. CRPIO, long back I have filed affidavit on those service. Matter is not coming, my lord. On 13.
Lords, I beg to mention item number 1. I have to file one amendment petition. Today I will file the amendment petition. Let the matter be fixed on Friday, Your Lordship, if Lordship permit.
On the prayer being made by Dr. B. N. Gogoi, learned counsel for the petitioner, the matter stands adjourned to be listed after.
On Friday, Your Lordship, 13. Matter is quite urgent. I will file today itself.
Friday, so as to enable him to file amendment petition. Prayer, Lord.
Develop.
I have a prayer for listing for motion. CRPIO on 11. I will file on 11 because on the 12th date is fixed before.
Okay.
Published.
May it please the lordship, my lord, with the consent of the other side, my lord. Item number 29 may be passed over for the day, my lord. It makes come about
29.
29. Well, my name is not shown, my lord. My name is not shown, but my lord,
You have put a
I'm for
appellant.
the
Appellant.
appellant, my lord.
Whether you
My lord,
have
last,
filed Ukalatnama there or not.
my lord, we have filed, my lord. We have filed. Possibly.
When?
My lord, at the time of filing, my lord,
Yes.
filable লাগিছে মোৰ নামটো তলত দেখায় এফ হুসেন আৰু তলত এফ হুসেন মালত and SM Abdul
Okay.
Item 20.
Mr. Abdullah, learned counsel for the appellant, with consent from the other side, press for listing the matter on
2 weeks
after 2 weeks. Prayer, Lord.
oblige your lord.
Please, Your Lordship, my lord. There is a fixed case, my lord, which was a part of, my lord. It was supposed to be listed on 27th of January, my lord. It is not listed till date. It's a part of matter, my lord. I'm praying before Your Lordship, my lord, just to list this case on next Monday, 16th. Next week, my lord. That's for admission. Yes, it's a part of matter. Fixed it. Admission hearings. Hearing matter. Then what was it? On Tuesday, on 1 week. 70.
May it please your lordship, I beg to mention for listing of two orders matter, any date your lordship may.
Consistent. I beg to mention item number 20. I have taken consent. In this case, my lord, in the memorandum of appeal, written statement has not been, my lord, annexed. So I want to bring it by way of additional affidavit.
Mr. Sahu, learned counsel for the appellant. You inform the other side.
My lord,
With consent from the other side, press for listing the matter after
next week, my lord, next week.
in the next week, so as to enable him to file. No, to enable him to bring on record the written statement file in the title suit number.
My lord, this title to. My lord, I'll provide it. I'll provide it.
Yes.
May I please your lordship? I beg to mention one IA, my lord. A compromise has been reached between the parties. The IA was filed on 18/11/2025. That has not been listed, my lord.
When do you want?
My lord, on 17, my lord.
Okay.
Yes, highly obliged.
Maybe also I item number 2. My lord, this is MSC appeal for listing under hearing column, my lord. This appeal of last around 6 years back, my lord.
6
Yes,
years back.
last listed.
Okay.
Listed on 12/2/2020.
Hmm.
Another was listed on 10/1/2020. Thereafter, my lord, they have changed the council and I'm being entrusted now with the cases, my lord. That can be listed for hearing or any date. 2019 matters, my lord.
Take it that from him. Yes.
May I please,
24.
my lord, item number 22.
20?
Two, my lord.
Yes.
My lord, we have some difficulty in this matter today, my lord. May we fix day after tomorrow, my lord.
Day after tomorrow.
My lord.
On the pair being made by Ms. S.S. Zia, learned counsel for the appellant, the matter is then adjourned to be listed on Wednesday.
Highly obliged.
Prayer, Lord.
May it be your lordship. Lordship, I beg to mention for listing an MSc appeal for admission from Wednesday, lordship. First time it will come, lordship. Oblige, your lordship.
And please, your lordship, I beg to mention item number 7, my lord. And this matter may be taken up next week, my lord.
On the pair being made by Ms.
PM Ahmed.
E.M. Ahmed, learned counsel for the petitioner. The matter is then adjourned to be listed in the next week.
Deeply obliged.
With the consent of the other side, I beg to mention item number 35. Filing it, please, next week. Okay.
As per number 2 and 3, I have only one prayer, Lordship. The matter may not fit between 28th of February to 27th of February. I have some difficulty, Lordship, and my senior also will not be here.
When do you want then?
Any other date other than those days?
As agreed by learned advocates of both the parties, recessal list the matter. In the first week of March,
No problem, Lordship.
Obvi-
Lordship, I have another prayer, Lordship, regarding item number 40. 5th March, item number 40, Lordship, the last matter.
yes.
Lordship, this is listed for the first time, Lordship. There is a delay petition I. However, I have some personal difficulty to this, so I am praying for an adjournment. Only for issuance of notice. It
Yes,
may
sir.
be tomorrow also, Lordship, if possible.
Tomorrow.
Tomorrow, only for issuance of notice.
Then why you are praying for adjournment?
Actually, Lordship, I have a medical appointment, Lordship. I have to
Today?
leave the couriers also.
Okay, on the prayer being made by Mr. S.P. Sharma, learned counsel for the petitioner, the appellant, the matter is then adjourned to be listed. Day after tomorrow, tomorrow is hearing day.
Obliged.
Wait, please, Lord. Lord, I
Yes.
beg to mention for listing of an item, FAO, for admission,
When?
any day in the next week.
Take it that from him.
May please lordships, may please, one my lord, MSc appeal matter, I am for the respondent claimant, my lord.
Mm.
And on last listed on my lord, in the year of 2021, my lord,
Now tell me, when do you want?
as a, just for listing, my lord. Listing on my lord, 16 or 17, my lord, for hearing, my lord.
Hearing day.
17, my lord. And similar, but two matters, my lord. I mean, my lord. So, obliged, my lord.
Take the listing of two MFA.
Obliged, my lord.
Take the Lord.
When?
Your Lordship on 10th of March. You will give
Next week.
24th February, usually. Can it be listed on the 4th week of March after?
Yes.
May it please your lordship, I beg to mention for listing of a FAO lordship for orders.
When?
Lordship, any date.
19th February.
Obliged lordship.
May please, your lordship. Lordship, I pray for listing a IA, your lordship, IA civil for orders, any date, your lordship, as per convenience. So,
I prayed for a hearing, my lord, last posted on my lord 2011, and the matter was left over, my lord. So, my lord, next week, any day, my lord, matter relating to my lord, MSc appeal, my lord. And matter of 2015, hearing, 26, obliged.
This is your lordship. I beg to mention for listing of one RSA lordship. It was last posted in the year 2019 lordship. Any date lordship.
Take it that from him.
20, can it be after 25th? Yes. Okay. Highly obliged lordship.
May please lordship, I wait to for listing lordship to the two matter, two related matter on 16 MFA.
What matter?
Lordship,
What matter?
MFA.
Take it that from him.
Lordship. Okay. Highly obliged.
My presence. So I like to mention one CRP IO for listing for withdrawal, my lord. Tomorrow, my lord.
Not tomorrow, day after tomorrow.
My lord, I'm obliged.
Which is lordship's permission. Because in the item number 20, I have already paid for adjournment. And one another prayer was there that I have filed an IA for stay of the interim order. That may be taken to for the lot.
Both the matter will be listed together.
Not the below, I have to bring the written statement. That is also there below. And at the same time, there may be also technical things.
Take a look at file now. Okay. Okay.
Public. Item number 2.
May it please, lordship. Statutory appeal against the granting of appropriate money. The main issue regarding my lord, the ground is that my lord, the attesting witness
which is supposed to see in the signature of the testator, my lord. Well, cross-examination, he said, my lord, I have not seen, my lord. The ground number 5. Ground number page number 4, my lord. The violation of section 63, my lord, of the Succession Act, subclause 3, my lord. Secondly, my lord, during the, my lord, physical and mental health of the testator, my lord, that was in question, my lord. They have admitted that before the execution of the will, for long 3-4 years, he was not well. And despite that, my lord, ignoring these facts, my lord, the probate has been granted, my lord. Kindly see, my lord, section 63, subclause 3, my lord. of
What
the
is
Indian-
there?
It says, my lord, the will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affirm his marks.
Hmm.
Has seen, has to be seen. During the signature of the testator, the attesting witness must seen that he has put his signature. That is the mandate of the law, my lord, 63, subclause C, my lord.
Hmm. No, whether you have taken such a play before the trial court.
Yes, my lord, that was plea has been taken, my lord. The will was not properly executed, my lord. That was plea was taken, my lord.
Hmm.
That part was ignored, my lord. Even the PW, my lord,
No,
PW2.
whether you have argued on that point before the trial court.
Yes, my lord. We said, my lord, will was not properly executed. And on that, my lord, we have placed our witness also. And although, my lord, this is a statutory appeal, my lord, first appeal.
Heard, Mr.
Sheila Ditharaj.
Learned counsel for the appellant. This appeal under section 384 of the Indian Succession Act 1925 is directed against a judgment and order dated 4/9/2025 passed by the learned additional district judge FTC Tinsukia. FTC number 2 Tinsukia entitled which will make it probate number case number 01 of 2020. It is to be noted here that by the impugned judgment and order dated so and so, the learned trial court has granted probate to the respondent herein. And one Subir Pal as co-executor under will number 22 of 2014 dated 23rd July 2014. In respect of the properties listed in the schedule A, C, D, E, and F. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order dated.
Four 2025.
4/9/2025. Admit. Issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Registrar shall call for the record from the learned trial court. List the matter after 4 weeks. In IA, you take down heard Mr. Siladitya, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure is preferred by the applicant for staying operation of the impugned judgment and award dated judgment and order dated 4/9/2025 passed by the learned additional district judge Tinsukia. In probate, Tinsukia granting probate in title suit, within bracket probate case number 1 of 2022. Mr. Siladitya, learned counsel for the applicant, submits that the connected appeal has already been admitted by this court and notice has been issued to the respondent. And the record has also been called for. And under such circumstances, there is a requirement of staying the impugned judgment and order dated 4/9/2025. Passed by the learned additional district judge, FTC number 2, Tinsukia, entitled suit within the probate case number 1 of 2022 to till disposal of the appeal. It appears that the connected appeal has already been admitted and the record has been called for. And notice has been issued to the respondent. Accordingly, taking note of the submission of Mr. Siladitya, learned counsel for the applicant, and also considering the facts and circumstances in the record, operation of the impugned judgment and order dated so and so stands state till returnable date.
Deeply obliged.
Item number 3.
May I please, my lord? Lordship, I have filed this revision against the order dated 15/10/2025 passed by the additional district and session judge Kamrup Metro, my lord. Impugned order, my lord, page 92.
No, by that impugned order, your case has been dismissed.
Yes, my lord.
But whether revision will lie against the order of dismissal?
Yes, my lord, that is a land grabbing case, my lord.
Maybe. Have you gone through section 13 of the Land Grabbing Act? (13)(1).
Yes, my lord. That is a appeal, my lord.
Yes. So since your case has been dismissed, you ought to have preferred one appeal under this section.
Yes, my lord. So,
You withdraw this, then you file appeal.
my lord, my limitation will be over if I am going to file the appeal.
Limitation, this,
So my.
when did you file this?
Liberty.
You file an application for condonation if there is any delay.
Yes.
Heard Mr. Ayer Mehdi, learned counsel for the applicant. No, for the petitioner. Mr. Mehdi submits that he may be permitted to withdraw this petition with liberty to approach this court again by filing appropriate petition. Pair allowed this CRP number 9 of 2025 stands a dispose of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Item number 4.
My lord, This honorable court has already passed the judgment, my lord. In this judgment, my lord stated that revision is lie.
Pardon?
Revision is lie in land grabbing case, my lord. The judgment was passed by this honorable court, my lord.
Okay.
Not so less.
We'll see that, but give me the judgment.
Last 27.
Number 4.
Silent.
27.
No, this order was passed in a case under Article 226 of the Constitution of India. Then the court held that to petition, file a petition under Article 227. But what about the statutory provision? 13?
Yes, my lord. There is, my lord.
Then
All right, my lord. I
do
will
we go by the act or by this judgment?
No, my lord, I will file the appeal, my lord. All right.
No, even then, you go through the provision.
Yes,
You let this court know after some time. You check it again.
yes, my lord. I will say.
You check it again.
Yes.
Number 4.
No, legal lordship. This transfer petition has been filed by the petitioner, your lordship, praying for transfer of titles to divorce 07 of 2025 pending before the court of Morigaon to Nagaon, your lordship. She is a poor lady, your lordship.
No, madam, you say no. What is the distance between Nagaon and Morigao? Few kilometers only. So what is the ground for transfer?
Ground for transfer, your lordship, firstly, the fact that the respondent is inserted the case Morigaon only to harass the petitioner, your lordship. The petitioner is now, petitioner has now become the permanent resident of Nagaon. She is staying with her parents, your lordship, and she has no source of income, your lordship.
What is this? The proceeding is pending now.
Yes, it is still pending, your lordship.
At what stage?
Stage is, your lordship, 2 dates has been gone, your lordship. Two dates only.
Heard Miss K. Fokon, learned counsel for
Stay may be granted, your lordship.
this petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transfer of TS within bracket D number 07 of 2025 pending before the Court of Learned District Judge Morigao to the Court of Principal Judge Family Court in Nagaon. Ms. Fokon, learned counsel for the petitioner, submits that the respondent herein is the husband of the petitioner who has instituted title suit within bracket D number 07 of 2025 before the Court of Learned District Judge Morigao. Ms. Fokon further submits that the petitioner is presently residing at her parental abode at Nagaon,
Yes, your lord.
at Nagaon, and she has no source of income, and it is not possible on her part to contest the aforementioned proceeding before the Court of Learned District Judge at Morigaon, and under such circumstances, she submits that the title suit number so and so may be transferred to the Court of Principal Judge, Family Court
No,
in Nagaon, Family Court in Nagaon. The submission of Ms. Fokon needs further consideration at this stage. Notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post with AD and also by usual process within a week from today. List the matter after 4 weeks. Interim pair of the petitioner will be considered on next date.
your lordship, today itself, she is facing lots of problem, your lordship.
When the next date is fixed. Next date is fixed on when?
Next,
On which date?
after 2 weeks, your lordship. Date. Well, 26, your lordship. Hmm? Oh, next date. That I don't have any idea. Last it was posted on 5th of February, I think, your lordship.
So let the other side appear. We will consider your interim pair. Next date.
She is facing lots of problem, that's why, your lordship. Stay may be granted, your lordship.
Let the other side appear. Next date you file an application before the trial court.
Yes, my lord. This is reviewed on petitions in the order 6/12/25 passed in title execution number 5 at annexure 12, page 85-86, whereby the learned civilian senior division Amin Gang rejected my prayer to correct the address, more particularly police station of the judgment date. The fact leading to this petition is that we have filed a title suit for specific performance, and that was decreed ex parte. Thereafter, they have come before the court judgment debtor for setting aside the decree, and that was rejected by the learned civil judge. Thereafter, we filed title execution petition, and that was also served. But what happened after servicing, when the draft shell deed was sent, that was remained unserved. Then the court passed an order for reissue. In the meantime, due to administrative change, the PS of the judgment debtor has been sent from Kamalpur PS to Sangsari. And the process server, he is inclined to go to that. As a result, we made a prayer before the learned civil judge to allow to correct the address, more particularly PS, in place of Kamalpur to Sangsari. But that was rejected. Hence, we have approached before this court for this revision petitions. And as a result, the execution case is stalled. Interestingly, the judgment letter appeared in the admission case also.
No, the question is whether the amendment being sought for is clerical or arithmetical mistake.
My lord,
Hmm?
according to that circumstances, it is a typological error because administrative sense of the jurisdiction, this is not beyond our control. Earlier it was common rule PS, now due to administrative sense, it is sanctuary PS. It is beyond our control, that's why we have made the pair under 152 as well, agreed with section 151, but the Landed Code has rejected that. Interestingly, they have appeared in the Kamalpur PS, showing Kamalpur PS. Judgment letter appeared in admission case also, page 73. And that was also reflected in the order sheet, my lord, of 1/3/25, page 78. Appear also.
Mr. P.C. Mazumdar, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure, the petitioner has challenged the order dated 6/12/2025 passed by the learned Civil Judge Senior Division Kamrup Amingao entitled Execution Case number 5 of 2024. It is to be noted here that while impugn order dated so and so, the learned executing court has dismissed the petition filed by the petitioner, being petition number 2341 for amendment of the decree, to change the name of the PS in the decree. However, the learned trial court, the executing court, has held that by holding that the amendment sought is, however, not typographical in nature as allowed by section 152 CPC. Mr. Mazumdar, learned counsel for the petitioner, submits that the earlier the PS was Kamalpur.
Kamalpur,
Now
Sangsari.
and now it has been changed to Sangsari, and change of the police station from Kamalpur to Sangsari is beyond the control of the petitioner, and under such circumstances, the learned executing court ought to have allowed the petition. The submission of Mr. Mazumdar needs further consideration. At this stage, notice be issued to the respondent of returnable in 4 weeks that be taken by registered post with AD and also by with speed post with AD and also by usual process within a week from today. List the matter after 4 weeks. After 4 weeks, take step.
Marfox, 2 weeks.
Your Lordship, we have filed this revision petition challenging the order dated 16/8/2025, whereby the civil court has dismissed our application under section 8 of the arbitration.
That's all right, but whether this revision petition will lie or appeal will lie.
My lord. My lord, there are judgments in which uh, the revision petition has been filed challenging the.
There are judgments.
I don't have it right now, my lord, but I can.
Okay, produce the judgment, we will see.
Yes, my lord.
You produce the judgment, we will see whether revision will lie or appeal will lie.
Yes, my lord.
Then day after tomorrow, you produce the judgment.
My lord, my senior counsel is not available, so he is in leave till 15th of March. So if you may fix it after.
Okay, in the month of March then.
Lordship, I'm for caveat as
You are for
I'm for caveat, Lordship.
caveat. Okay. In caveat, you take down caveat or would be hard. Caveat stands for this is hard miss. Your name, please.
Prachi.
Learned counsel for the petitioner. And also hard miss.
Lordship,
Learned counsel for the respondents. This petition under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure. In this petition, the petitioner has put to challenge the order dated 16/8/2025 passed by the learned civil judge senior division Kamrup at Aminggaon in Mizje case number 374 of 2024, arising out of title suit number 161 of 2024. Notably, by the impugned judgment, the impugned order dated so the learned civil judge senior division Kamrup has rejected the petition filed by the petitioner under section 8 of the Arbitration and Conciliation Act 1996, filed by the petitioner for referring the parties to arbitration. Thus, Arbitration and Conciliation Act. Arbitration. That's it. Yes. That was good. You have the act with you?
Arbitration Act.
Yes.
No, my lord.
No. You see section 37 1A.
Yes, my lord.
Arbitration.
Is it there?
This is CPC, my lord.
Act is not there.
CPC.
Thank you. Yes, my lord. My lord, I found a judgment which I don't have it, in which it was written that held that if there is some jurisdictional error, then it can also be taken to the.
No, here you see, you file an application under section 8.
Yes, my lord.
The petition was dismissed.
Yes, ma'am.
You were before this court challenging that order. So this section 37 provides that an appeal will lie.
Yes, my lord. But
Then
my lord, the order was suffering from a jurisdictional error. That's why we have filed the revision petition.
Okay, you produce those judgment. We'll fix another date. When?
After 15th of March, my lord.
After 15th of March.
Yes, my lord.
Okay. কি করলো last না? But perusal of the provision of section 37 within bracket 1 within bracket small a of the Arbitration and Conciliation Act reveals that an appeal will lie against an order passed under section 8 of the said act. In that view of the matter, it is provided that the learned counsel for the petitioner shall satisfy this court on next date regarding maintainability of this petition under Article 227 of the Constitution of India. List on.
Obliged, my lord.
Item 8.
May it please, Your Lordship. My lord, this petition is filed against the amendment allowed in favor of the plaintiff, my lord. Here, my lord, my only question before your lordship, whether under order 6, rule 17 CPC, my lord, the entire plea can be sensed by the plaintiff by way of amendment. Because at the time of filing of the plaint, my lord, they said that they are inherited the property in place of original pattata. And thereafter, my lord, we filed the written statement. After filing the written statement, when we take the plea that we have purchased the suit land, They changed the entire stand, my lord, and they have taken the plea that orally they have purchased from the original patata. And that amendment was allowed by the court below. That point is to be decided by you. May I have this plaint, my lord? Your lordship will turn to page 11.
Yes, page number?
Page number 11, my lord. I am reading para 1, my lord. That Asiron Bawa, so Khutiandar a plot of land measuring 7 biga. Then the para 2, my lord. That Asiron Bawa died in the year 71, leaving the following legal years. That Asiron Bawa was the original Khutiandar of plot of land measuring 7 biga so and so. That Asiron Bawa died in the year 71, leaving the following legal years as follows. My lord, it is the repetition. That the plaintiff and pro forma defendants have been owning and possessing, enjoying the peaceful scheduled land without any interference from any corner since the day of predecessor in interest of Asiron Bawa. That is their stand, my lord. And now in para 4, it is said that we are landless people from Borpata district came to the land and said that for temporarily we may be allowed to reside there. We reside there, and thereafter, my lord, after 3 years, we refuse to vacate the land. That is their case. And your lordship would be pleased to see the prayer. In the prayer portion, it is said that cash possession title declaration may be due. Now what happened, my lord? After filing written statement, we have filed written statement claiming that we have purchased the seat land. Now, my lord.
Okay, Mr. Sheikh, let notice go at this stage.
My lord, if your lordship please to issue notice in that case, my lord, further proceeding is to be stayed. Otherwise, my lord, what will happen on the amendment?
What stage the case
amendment
is
case
pending now?
Case will proceed on amendment, my lord.
At what stage it is pending?
My lord, it is in the filing objection, my lord.
Filing objection.
Yes. It was on.
Okay, let the other side appear on next date. We will consider your interim pair.
My lord.
Next date.
My lord, short date may be given, my lord. In the meantime, my lord, further proceeding may be stayed.
No.
Otherwise, there may be difficulty.
On next date, we will consider your interim pair.
Okay, my lord.
Heard Mr. M.S. Sheikh, learned counsel for the petitioner. Aggrieved by the order dated 22nd of October 2025, passed by the learned civil judge junior division number 1, come JMFC Gwalpara, in Mize case number 40 of 2024, arising out of title suit number 62 of 2022. The petitioner approached this court by filing the present petition under Article 227 of the Constitution of India. Notably, the learned trial court, while impugned order dated so and so, has allowed the application filed by the plaintiff struck opposite party under order 6 Rule 17, read with Section 151 of the Code of Civil Procedure by imposing a cost of rupees 2,000 upon the petitioner. Mr. Sheikh, learned counsel for the petitioner submits that the entire schedule has been changed.
Yes, my lord. Entire stand in the original plant is changed.
Entire?
Have the
Entire?
entire stand in the original plant, my lord, changed
Okay.
by filing this amendment petition.
Mr. Sheikh, learned counsel for the petitioner submits that by filing the aforementioned petition, the opposite party, plaintiff stroke opposite party herein, has changed his entire stand, which according to Mr. Sheikh is not permissible. And under such circumstances, Mr. Sheikh, learned counsel for the petitioner, has contended to allow this petition. And he further submits that in the event of issuing notice to the opposite party, the further proceeding of the title suit number 62 of 2022 may be stayed. The submission of Mr. Sheikh, learned counsel for the petitioner, needs further consideration at this stage. Notice be issued to the respondents, returnable in respondent opposite party, returnable in 4 weeks. Step be taken by registered post with ADN, also by usual process within a week from today. Not registered, speed post. Interim period of the petitioner will be considered on next date.
My lord. My lord, step will be by speed post, my lord.
Speed post.
My lord.
Yes.
As usual post may not be necessary, my lord. Nowadays, as usual process, my lord.
Not
that-
necessary.
That should not be there because, my lord, that is taxing to the petitioner. Because speed post is like this, my lord. Tracking we can do. Even
Yes,
while
that can
petition.
be.
So by speed post will do, my lord.
Okay,
That
let
as-
there be both the process. You take step by speed post.
My lord. No, otherwise, my lord, what the registry will say that you have not taken this step.
No, not necessary.
My lord.
If you take step by speed post and the notice is delivered, then definitely we will take cognizance of the
My
same.
lord. My lord, that as usual process may not be there. That order may not be there. Otherwise, we have to take double step, my lord. That is the problem, my lord. My lord, when speed post is there, my lord, this as usual post is not necessary.
Okay.
It lessen the burden of the
Okay,
registry also.
okay.
Much obligation.
Number 9.
Usual process to dispense kora having
This petition has been filed against the impugned order dated 31/10/25. Lordship will find as page 48, the impugned order, page 48. By this order, my lord, the Misja case number 77/25, which is a petition under order 39 rule 2A, violation of the injunction order, has been suspended and kept in abeyance till disposal of the another Miss case, which is an amendment petition, my lord. So, my lord, by this order, the violation of injunction order has been suspended, which cannot be, my lord, because this honorable court has passed injunction order. Lordship will find page 14 is the injunction order, that is status quo. Relevant portion is Lordship, page 20. Page 20, Lordship, para 16. This court hereby directed both the sides to maintain status quo in respect of the suit land till disposal of the suit, my lord. And after receiving this order, the respondents has started construction in a portion of a land. And against that, a violation petition has been filed before the trial court. Trial court issued notice on the violation petition And in the violation petition, your lordship will find, page 46, Ms. J 77 was registered and notice was issued and date was fixed for furnishing copy and objection by the defendants. Thereafter, in the next date also they took time, page 47, for filing objection. In the meantime, an amendment petition was come up, and that is registered as Ms. J case number 78, page lordship will find 48. And on that date, impugned order was passed by suspending or kept in abeyance of the Ms. J 77 till disposal of the Ms. J number 78, which is the amendment petition, my lord. So amendment petition may run, that cannot hamper the violation petition, my lord. So if that is kept in abeyance, they will, by this advantage, continue further proceeding, which will create a chaos, my lord. So my prayer is that the lordship may suspend this order and may issue notice, my lord. Impugned order dated 31/10/25. Violation is continuous process, my lord. That cannot be stayed. Contempt or violation has no link with the main case, my lord. The injunction order cannot be suspended. That is there. And earlier also at page 28, you will find there is a order by this civil judge that
Pardon
if
me,
there
sir,
is.
your name, please?
Yes, not, madam.
Learned counsel for the petitioner. The order dated 31st of October 2025, passed by the learned civil judge senior division Dhuburi in Ms. J case number 77 of 2015, passed in title suit number 32 of 2018. Is challenged in this petition under Article 227 of the Constitution of India, read with section 151 of the Code of Civil Procedure. It is to be noted here that by the impugned order dated so and so, the learned trial court has kept in abeyance the proceeding under Order 39 Rule 2A, which was initiated pursuant to the order passed by this court in FAO 43 of 2023 and the order dated 29/7/2024. Now, after the order of this court,
Yes.
they have started the
Construction,
violation
ma-
proceeding.
Yes, madam. By violating this order, although civil judge has directed they don't proceed with the order and proceed with any construction or change in the
Then
nature.
thereafter, the other side has filed one amendment petition.
In lordship. No,
And
amendment petition
in
was
that
filed.
proceeding, this proceeding has been stayed.
Amendment petition was filed by the plaintiff for for some implement of a party, a new party, my lord. And in on that's Ms. J number, that is Ms. J number 78, which is now pending.
Okay. তোমার কি করলো এটা? Initiated by the learned trial court for violation of the order dated 29/7/2024 passed by this court in FAO number so and so, wherein this court was pleased to direct both the parties to maintain status quo in respect of the suit length till disposal of the suit. Mr. Nath, learned counsel for the petitioner, submits that while the proceeding initiated by the learned trial court under order 39 rule 2A was pending, then the plaintiff has filed one amendment petition for implement of some other
Some other new parties.
some new parties. And while dealing with the said petition being J case number 77 of 2015,
No, madam, that is 78.
78,
Yes, madam. That is later on, 78.
78 of 2025.
25.
The learned trial court has kept in abeyance the proceeding under order 39 rule 2A, which according to Mr. Nath is not permissible. And under such circumstances, Mr. Nath has contended to admit this petition and to issue notice and to stay the impugned order. Whereas the submission of Mr. Nath needs further consideration at this stage. Notice be issued to the respondent. Opposite party returnable in 4 weeks by speed post and also by usual process within a week from today. Further, considering the submission of Mr. Nath, learned counsel for the petitioner, and also the facts and circumstances on the record, operation of the impugned order dated 31st of October 2025, passed by the learned trial court in J case number 77 of. It is 2025 or 2015?
25, madam. 25.
But what you have stated in the cause title?
That is maybe mistake, madam. 25. Post-title case. Lordship 31-10-25, madam. Lordship first page. 31-10-25. 2025. Impugned order dated 31-10-25, passed in J case number 77-15. Oh, 77, that will be 25. That mistake, madam. That should be 25. No, 77-25, 15 হয়েছে। That is not, this is just title. That is mistake, madam. I will cut it. That is out of typing mistake, madam.
Till returnable that list
That
after
is
4
50.
weeks.
Yes, madam. I will cut. Obliged. Obliged.
May it please your lordship. And
Yes.
this case is not fit for settlement because insurance liability in this case, my lord.
No, is there any chance for conciliation?
Actually, we have, insurance company has no liability.
Pardon?
Insurance company has no liability in this case. So hearing may be required.
But it has been listed under the column for referral to the special mediation. What to do?
Well, lordship may, hearing is required in this case, my lord.
Pardon?
Hearing is required, my lord.
Hearing is required. Heard Miss Roy, learned counsel for the appellant, and Miss learned counsel for the respondent number?
What?
Respondent number 1. This appeal is listed under the column for referral to the special mediation. Drive. That's mediation for the nation. However, Ms. Roy, learned counsel for the appellant, submits that the appellant has no liability and no purpose will be served by referring the same to the mediation. And she submits that the matter may be listed for hearing.
Your
Yes,
lordship
any
may fix the
objection?
date, 2014 matter.
Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that registrar shall list the matter for hearing on a date to be fixed by the registry. Registry will fix the date. Next item.
May I please, my lord?
Yes.
Not say I relied his husband because, my lord, there is a appeal provision is there, that's all right.
Yeah.
But no constitution of the special court is there, my lord. The court, special appellant court should frame by the notification of the government, my lord. So there is no appellant court is now. That's why the in the judgment the writ was filed, but that writ was not lied, but the judgment only clearly stated in para number 20 of the judgment, my lord. The present writ petition has been preferred by the styling it a writ petition under Article 226 of the Constitution of India on the premises that road there is a provision of the appeal under Section 13 of the Land Grabbing Act. The special court which can entertain the dispose of an appeal arising out of any judgment of the special tribunal declaring there the civil liabilities or the criminal liabilities has not been constituted government till date. Till date government not constituted an appellant forum, my lord. That's why the revision is lie as per this judgment, my lord. 227 lies. So para number 25 of this judgment, my lord.
Okay, we will confirm it from the government side. He will inform the council, government advocate. We'll after hearing, we'll consider your submission. Wait for some time.
Yes, ma'am.
Not fit for mediation. Yes.
My lord, the very unfortunate things happened in this case. My lord, we filed a claim petition for compensation before the Motor Accident Claims Tribunal. Claims Tribunal dismissed the claim petition. And further direction was passed to the CID for investigation against the police officer who investigated the case. The tribunal had doubt in mind that there was a collusion between the police officer and the claimant. That's why CID was directed to investigate. My submission before your lordship is there. My lord, when the tribunal thought that it should be investigated by CID, our claim petition ought not to have dismissed. Our keeping pending report could have been called from the CID. The CID will investigate, then CID will submit a report. Accordingly, the claim petition will be decided. But unfortunately, claim has been dismissed and direction issued to the CID for investigation. Now, my lord, problem is there. Suppose, assuming that the investigation is complete, the report has come in our favor, then what will happen to the claim petition? Claim petition has already been dismissed finally.
No, that's all right. Whether that direction was carried out or not by the CID.
CID is investigating, my lord. Claimants are called for.
Charge sheet was filed against the errand officer and the case is pending before the special judge.
Charge sheet submitted by the CID.
Yes.
Okay.
Submitted against the errand officer. But in false accident information report was issued. That is why the case was dismissed. On the basis of the VTNP, the vehicle issued was not involved.
Do you have the report? The CID report?
Yes.
CID
My lord, actually, we don't have any access to the CID. That's why, my lord, CID may be directed to submit a copy of the charge sheet. If my learned friend is submitting that CID has already submitted charge sheet against that police officer,
Last occasion he submitted.
copy may be called for.
Last occasion he submitted the charge sheet.
show me the charge sheet number.
No, I did not show the charge sheet number. I was not aware of the charge sheet, whether it has been filed or not.
That is why.
Anyway, my lord, your lordship can direct the CID to file a copy of the charge sheet before this honorable court.
No, government side is not before this court now. Here, government is not a party here.
Actually, my lord, we did not think that government will be necessary party.
Government as a party.
If your lordship direct, then we will include, no problem. We'll file the infringement petition. But the matter goes to be more critical.
Okay, take down. Heard Mr. Mullah, learned counsel for the petitioner. Mr. Bhatt, learned counsel for the respondent. Number? Respondent number 5. One. Respondent number 1. This appeal is listed before this court today under the column for referral to the special mediation drive, as mediation for the nation. However, Mr. Bhatt, learned counsel for the respondent number 1, submits that this matter is not fit for referring to the mediation. However, no, Mr. Mullah, at this instance, Mr. Mullah, learned counsel for the appellant, submits that the appellant herein has filed claim petition before the member Motor Accident Claim Tribunal, Kamrup, Gauhati. But by judgment award dated, by judgment dated 16/5/2014, the learned tribunal has not only dismissed the claim petition but also directed the CID to carry out investigation. To conduct a thorough investigation and to take appropriate action against the concerned police officer of Dhola PS, who had filed the accident information report.
Actually, my lord, it is a fit case for remand to the tribunal. Tribunal should wait till it receives the result of the final outcome of the investigation.
By observing that it is a collusive case and police of Dhola PS, on being approached by the claimant, subsequently issued the police report, that is Exhibit 1, showing the Maruti car as the offending vehicle in place of unknown truck, which in fact caused the accident and managed to run away. Mr. Mullah further submits that the learned tribunal ought not to have dismissed the petition while directing the CID to carry out the investigation. Mr. Bhatt, learned counsel for the respondent number 1, however, submits that as per his information, investigation has already been completed by the CID and search sheet has been submitted against the erring police officer. But in support of the aforementioned contention, Mr. Bhatt could not produce any supporting document before this court. Mr. Mullah also submits that he is not accessible to the record of the CID. Under such circumstances, this court deem it appropriate to complete the state of Assam as a respondent number as a respondent number as respondent number 4. Okay. Okay, we have informed the government advocate. Let her come. After some time, we will pass the order. We will complete the order.
No.
Because if she remains present, then there is no requirement for issuing notice. We will direct her to obtain an instruction and to produce the search sheet and other documents. Let her come.
May please lordship, this appeal is not yet admitted. Appeal not admitted.
Appeal not admitted, but can it be referred to the
Yes,
mediation?
my lord. Admit, and I will ready to pay the 50% and refer to the mediation. My lord, my stay petition.
Regarding admission, I am subject to the 50% of the paid amount.
My lord, I have a IA for staying.
Heard Mr. R.C. Pal, learned counsel for the appellant. And also heard Mr.
Is
A.
Google.
H. Gogoi, learned counsel for the respondents. Respondent number 1. This appeal under section 173 of the MB Act is directed against the judgment and award dated 31/10/2023 passed by the learned member Motor Accident Claim Tribunal North Lakhimpur in MSC case number 21 of 2018. It is to be noted here that by the impugned judgment and award dated so, the learned tribunal has directed the appellant herein to pay a sum of rupees 16,64,600, being the compensation along with interest at the rate of rupees 7.5% per annum. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 31/10/2023. Admit. Issue notice to the respondent. However, no formal notice is required to be issued to the respondent number
1.
Respondent number 1, since Mr. Gogoi entered appearance and received notice. However, extra requisite copy of the memo of appeal be furnished to him during the course of the day. Step upon rest of the respondent be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned tribunal.
Finally, allow the civil to do that amount deposited by them.
Yeah, right. Petition to the order to right?
IAU take down, heard Mr. R.C. Pal, learned counsel for the applicant, and Mr. Gogoi for the respondent number 1. The respondent opposite party number 1. This application under order 41 rule 5. Read with section 151 of the Code of Civil Procedure is directed. Is preferred by the applicant for staying the operation of the impugned judgment and award dated 31/10/2023, passed by the learned member, Motor Accident Claim Tribunal, Lakhimpur, in MSC case number 21 of 2018. Mr. Pal, learned counsel for the applicant, submits that connected appeal has already been admitted by this court and notice has been issued and the record has been called for. And as such, there is a requirement of staying operation of the impugned judgment and award till disposal of the appeal. Having heard the submission of learned counsel for the applicant, this court has carefully gone through the application and the documents placed on record. Then it appears that MSC appeal number 540 of 2025 has already been admitted for hearing. And notice has been issued to some of the respondents. And record has also been called for. And accordingly, taking note of the aforementioned facts and circumstances, and also the submission of Mr. Pal, learned counsel for the applicant, operation of the impugned judgment and award dated so and so stands state till disposal of the appeal, subject however to depositing 50% of the awarded amount before this court, before the registry of this court. Mr. Gogoi, learned counsel for the opposite party number 1, submits that the opposite party number 1 may be allowed to withdraw the amount to be deposited by the appellant before the registry of this court. There is only one claimant.
Yes.
They are allowed. They are allowed. 50% of the awarded amount being deposited before the registry of this court shall be released in favor of the respondent number 1, respondent opposite party number 1. After 4 weeks.
Timing.
Highly ob-
Madam, we want some information from you. Information is this civil revision petition is filed by the petitioner for dismissal of his case filed under Assam Land Grabbing Act. But in fact, there is one section in the Act, section 15.
13, madam.
13.
Yes.
Which provides for appeal. But Mr. Medhi submits that the appeal has to be filed before special court, special tribunal. But the government has not constituted a special court and tribunal for which this revision petition is preferred. Now the question is whether in fact the government has not constituted the special tribunal for dealing with the appeal under Land Grabbing Act. This information is required. You inform this court as early as possible. And another matter is one appeal is filed against the judgment against judgment passed by the Motor Accident Claim Tribunal, Gauhati. The claim petition was dismissed by the tribunal and directed the CID to conduct an inquiry against the police officer who has prepared the report. And Mr. Bhatt submits that the CID has conducted investigation and submitted charge sheet against the erring police officer. To deal with this appeal, that charge sheet filed by the CID is required. Therefore, we are impleading the government of Assam as party here. Mr. Mullah has furnished one copy of memo of appeal to you along with the judgment of the tribunal.
Well.
You obtain the certified, whatever copy of that search sheet filed by the CID and produce the same before this court on next day.
But may treat the matter.
After 2 weeks, after 2 weeks.
One date may kindly give you. One date may kindly give you.
Yes, we will fix that date. Copy.
On 23rd?
23rd. কি ক'লা আগৰটো? Since Miss Didi does learned additional senior government advocate entered appearance, no notice is required to be issued to the newly impleaded respondent. However, a copy of the memo of appeal and also the impugned judgment passed by the learned tribunal be furnished to Ms. Das during the course of the day. Further, Ms. Das is directed to produce the search sheet submitted by the CID against the erring police officer before this court on 23rd February.
Much.
Madam, you can obtain the information after some time?
I can check that.
Yes,
Special court,
2 p.m.
Yes.
Okay.
special court,
Special court.
court, not tribunal. Tribunal is there, but special court is not there. Under section 14 of the Land Grabbing Act.
Okay. We'll resume after 5 minutes.
এইটো নাই এটা
Number 13?
May it please your lordship. Lordship, my name has not been shown in the cause list. It may come day after tomorrow, lordship, without my saying. I'm the Hana.
Sir, are you linked to Metro?
Hmm?
Mediation going to get
Yes, we're down to no file yet.
appeal photo has not been given to me. Without permit, without valid road permit, driver was not.
You were the appellant here?
I'm the appellant, lordship. My name has not been shown in the cause list, so I could not come with the file, lordship.
Okay, file is not available with you.
Not available.
Okay.
I came to know only
Heard Mr.
day after.
Goswami, learned counsel for the appellant, and also heard Mr. A.B. Day, learned counsel for the respondent number
1.
Respondent number 1. Mr. Goswami submits that his name has not been reflected in the cause list, and as such, the relevant file is not available with him. And he tries for listing the matter day after tomorrow. Bear along.
If I may, my lord, there are other 5 connected cases of the same issue out of the same accident, other 5 connected cases of file. Like,
Number, details.
sir.
Little.
Sir, my lord, I can give those numbers. All those cases can come on day after tomorrow.
No, whether you have filed those cases or not.
I have filed my Wakalatnama, they have filed the appeal, my lord. Those cases have been admitted already
Okay,
and numbered also. I'll give the
Okay.
details, my lord.
okay.
Number.
Mr. Day further submits that in connection with the same accident, another 5 appeal is being preferred and pending before this court, and this matter may also be tagged with those appeals. Being MSC appeal number, you give the number to
I'll
the
give
court
the
master.
amount.
Rest is always the matter. When?
Day after tomorrow on 11.
Day after tomorrow.
Admission, I guess.
Okay.
I got 14.
May it please your lordship.
Hmm.
In this case, lordship, although pain recovery has been allowed, there are some
Oh.
other grounds on which also, in this case, particular case, lordship,
Hmm.
in 14.
Hmm.
Although pain recovery has been allowed, there are some other grounds on which I have filed this appeal. So maybe admitted,
Heard Mr. Goswami, learned counsel for the appellant. Mr. M. Khan for respondent number 1 and 2. This appeal under section 173 of the MD Act is directed against a judgment and award dated 16/5/2025 passed by the learned member MSCT Bongaigaon in MSC case number 129 of 2021, filed under section 166 of the IMB Act. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated so and so. Admit. Issue notice to the respondents returnable in 4 weeks by register, no, by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 and 2 since Mr. Khan, learned counsel, entered appearance and received notice. But extra requisite copy of the memo of appeal be furnished to him during the course of the day. Place the matter after 4 weeks.
Let's stay petition. I'll deposit 50%, but subject to providing a indemnity bond. He has agreed to that.
Okay. Furnish one bond. But why two appeal, no, two IAs are there?
There's no delay. Delay has been condoned.
Okay, that has been disposed of. Okay, you deposit 50% of the amount. And same shall be released in favor of the respondent number 1 and 2, subject however to furnishing a bond, indemnity bond.
Obligation.
It's correct of the same case, Lordship. We have filed an appeal that has already been offered notices, but may correct it.
Okay.
MSC appeal number 3.
Mr. Khan further
Yeah.
submits that into appeal to Lehiva. Submits that the respondent herein has also preferred an appeal against the impugned judgment and award dated so and so, being the MSC appeal number
310/2025.
310/2025, and he submits that both the matters may be taken together and to be heard together. Parallel SSL list this MSC appeal number so and so along with MSC appeal number so and so on. Next step.
Obligation.
I don't for admission.
Good morning.
I don't know what.
Lordship, it was heard by your lordship.
On last occasion, this matter, lordship directed to after one the whether government prefer to go in either selection process or go for a phase selection process. But if my instruction is that in the affidavit of position filed on behalf of the director, we have prayed for allowing us to go for to withdraw this selection process and go for a phase process as per our new activity. This is my instruction. Therefore, the deponent complete says that it's honorable court to allow the deponent to withdraw the idea selection process for the post of regular principal national higher secondary school Nagaon had advertisement dated 21/6/2016 and further allow the deponent to initiate phase process to appoint regular principal of national higher secondary school Nagaon as per existing service.
Yes, sir, let them initiate fresh process.
Lordship, but lordship will kindly appreciate
And
the
you
circumstance.
participate in the said process?
Lordship, the circumstances under which this repetition was preferred, Lordship. It was because of them, Lordship. They acted in a manner in which the rule did not prescribe, Lordship. Lordship, that Lordship, in my reply, I have stated, Lordship.
No, now the earlier act was repealed. New act was enacted.
Yes, Lordship. But my submission would be, Lordship, that government had already, Lordship, given a instruction to the inspector by which a new committee was instituted, and that school selection committee conducted the selection process, Lordship. It was done twice, Lordship. So that is never prescribed under the rules. So that instruction by which the government prescribed the new constitution of the new school selection committee, Lordship, that would operate in this matter, Lordship. And since the government themselves, Lordship, had taken a step to continue with the process by that, Lordship, communication, so that needs to be finalized, Lordship. That is what is there in the reply, Lordship. Affidavit in reply, Lordship. Paragraph 4. Lordship, what had happened in this case? Lordship, the school selection committee had initially forwarded my name to the state selection board, Lordship. Thereafter, state selection board recommended my name to the government, Lordship. Thereafter, the joint secretary was there in the state selection board, and he himself took a decision on behalf of the government, Lordship, that the selection process, there was a flaw in the school selection committee that was constituted. And therefore, Lordship, there is a communication whereby the matter was remanded back to the school selection committee. At that stage, I approached this honorable court, and this court protected me, Lordship. Kindly have a look at that order, how I was protected, Lordship. It's 21/6/2019, Lordship.
Page number.
No, it's order dated 21/6/2019 in this case, Lordship.
Twenty-one.
21/6/2019, the first order, Lordship. It page no order to bottom order. Lordship, heard Mr. So-and-so, assisted by so-and-so learned counsel for the petitioner and Mr. So-and-so, learned standing counsels, secondary education department for the respondent numbers 1 to 4. Matter selection and appointment of regular principal in National Higher Secondary School, Lamding, a provincial secondary school of the state pursuant to advertisement dated 21/6/2016. The petitioner is aggrieved as the respondents in the secondary education department by its communication dated 8/5/2019, considering the process of selection for the said post held on 14/12/2016 in the concerned school being vitiated, directed for fresh selection for the said post amongst the candidates who applied and participated in the earlier selection process, pursuant to which the member secretary of the school selection committee of National Higher Secondary School, Lamding, on 15/6/2019 issued notice directing the candidates, including the petitioner, for the fresh selection to the post of principal in the said HS school to be held on 23/6/2019 at 11:30 AM. It is submitted by the petitioner that he was one of the empaneled candidate for the said post of regular principal in said National Higher Secondary School, Lamding, being selected by the concerned school selection committee on 14/12/2016, and was duly recommended by the state selection board to the said post of principal on the basis of selection held on 14/12/2016. Issue notice returnable by so-and-so as Mr. J. Avedin, Learned Standing Council, Secondary Education Department, accept notice on behalf of so-and-so. Formal notice need not be issued to those respondents. However, the petitioner shall serve extra copy so-and-so. The next paragraph, the petitioner shall take steps so-and-so by the steep personal service so-and-so. Thereafter, Lordship, the next paragraph. In the interim, the respondent number 5, School Selection Committee of National Higher Secondary School, Lamding, shall keep the records of selection for the post of regular principal by the said HS school to be held on 23/6/2019 in seal cover, and the said selection shall be subject to outcome of this writ petition. So that was the order passed, Lordship. Subsequently, the seal cover was opened on 4/12/2024, Lordship. So, and Lordship will also peruse the communication by which that selection was to be done again, Lordship. That is at page 27, Lordship. As your Lordship got it.
I'm reading from the third paragraph, Lordship.
Hmm.
The selection for the post of regular principal of National HS School Lamding took place on 14/12/2016 in pursuance to the advertisement dated so and so. Rule 13 of the rules of 2003 relates to procedure for selection of principal of HS School, and Rule 84 of the said rules 2003 relates to constitution of school selection committee SSC. The state authority for the purpose of the said selection issued office memorandum dated 6/6/2014 in conformity with the rules of 2003. The DSC Assam also issued an order dated 23/6/2016 laying down the criteria for distribution of marks to be awarded to the candidates in the selection. In the instant case, the Honorable Court came to the finding that the constitution of the SSC was not in conformity with the OM dated 6/6/2014, issued in conformity with the rules of 2003. In the school selection committee, instead of the vice principal or PG teacher, one assistant graduate teacher was appointed as the teacher representative. Though there is no infirmity regarding allotment of marks, but such deviation in respect of the constitution of the SSC vitiates the entire process of selection. Upon perusal of the provisions of the said rules and the aforesaid OM and the direction passed by the Honorable Court by judgment and order dated 14/3/2018, passed in WBC number so and so, it is observed that the earlier process held on 14/12/2016 for selection to the post of regular principal of National HS School Lamding is vitiated, as the constitution of the SSC was not in conformity with the provisions of the rules of 2003. The concerned school, the school selection committee authority may go fresh selection for the said post amongst those candidates who applied and participated earlier in complete compliance to the provisions of the rules, criteria, norms laid down through OM dated 6/6/2014 and the order of DSC Assam dated 23/6/2016. Now it is directed that the inspector of schools Nagaon shall constitute a new selection committee as per guidelines and may go for a fresh selection for the said post amongst those candidates who applied and participated earlier in complete compliance to the provisions of the rules, criteria, norms laid down through OM dated so and so and the order of DSC. So, Lordship, this was the order by which, Lordship, the selection was continued, Lordship. So the government itself, Lordship, continued with the selection process. Now they come up with another place stating that the new rules have come in. So, Lordship, in fact, this order was passed after the new rules had come in, Lordship. So they cannot change their stand, Lordship, here and there, again and again in one case, Lordship. That is my submission, Lordship. And Lordship, he is going to retire in November this year, Lordship. So for a fresh selection to happen and to take part and for him to participate.
But the problem is that you allowed the other person retired from their service. Only thereafter you are pressing the matter.
One more aspect is there, Lordship. They did not approach this Honorable Court at any point of time, Lordship. And herein in this order itself, Lordship, there is reflected that there is no infirmity with the marks awarded to the petitioner, Lordship. But then, Lordship, that was subsequently changed, Lordship, when the new school selection. I'm not on that, Lordship, but then this should be given an end, Lordship. This.
Yes, Mr. Datta.
Lordship, that earlier selection was 14/12/2016, my lord. That is referring, Lordship. That was developed by the Honorable Court in the earlier stage of litigation. And as per this Honorable Court direction, new selection has been constituted with a new selection body, Lordship.
No, this court never directed a new selection.
And it will read, Lordship, page 23, Lordship. That order, Lordship, passed. Order passing 1 to 90. The order 7 to page 11 to page 22, Lordship. 23, Lordship, paragraph 20. In the present case also, Lordship, the issue relating to appointment of regular principal of the state national higher secondary school Lamding pursuant to advertisement dated 21/6/2016, for which interview was held on 14/12/16 is pending for the state selection board. Consider an respondent in the secondary education department is yet to take a decision in that regard, and further the representation of the petitioner filed before the respondent authority are yet to be disposed of. For the reason above, and considering the state that which petitioner has opposed this court challenge the selection and appointment to the post of principal in National Higher Secondary School Lamding, pursuant to the advertisement dated so and so, this court is of the view that patent petition being premature is not maintainable, and at this stage neither the petitioner nor the respondent have acquired any right to the said post of regular principal of said National Higher Secondary School Lamding. It is noted that page 21, considering the above, it is observed that concerned state selection board and the government of secondary education department is the official respondent hearing shall comply with the provision of the national provision of Assam Secondary Education Service as amended and office memorandum of the state government in the secondary education department is so and so, as well as order of this director of secondary education department 26/6/16 in proper perspective as noted above before finalizing the selection to the post of principal of National Higher Secondary School Lamding in pursuance of the advertisement dated so and so. In pursuance of their order of it, that one speaking order was passed for 6 days.
Yes?
So page 25. Next chapter. In the seen and peruse the order passed by the Honorable Gauhati High Court dated so and so, filed by Srimati Ratnath Datta, the Honorable Gauhati High Court was given in that selection process. Present petitioner lordship appeared in the CL number 1 lordship. The Honorable Gauhati High Court was given a direction that state respondent shall comply with the provision of 11 provision of the Assam Secondary Provincialization Service of 2003 as amended and office memorandum of the state government dated so and so, and the order of the director of secondary education department 23/6/2016 in proper perspective. Also seen and perused the report submitted by the inspector of school Nagav Commissioner 5 memo number dated 12/11/18. In this connection, a hearing was taken on 23rd of May 2028, which was attended by Inspector of School Nagav, Dr. D.N. National HSC School, the principal in charge National HSC School Lamding, Srimati Ratnath Datta, the petitioner, and also Shankar Ranjan Paul, a candidate empaneled at CL number 1 by the school selection committee. On examination of the list prepared by the school selection committee and forwarded by the Inspector of School Nagav, it is seen that there are 4 candidates in the panel of Shankar Ranjan Pal who has obtained 11 marks out of 15. Shri Sudip Datta has obtained 10 marks out of 15. Srimati Ratna Datta has obtained 7 marks out of 15. And Devasis Lahiri has obtained 7 marks out of 15. The panel list has been duly signed by Chairman, Member Secretary, Selection Committee, Shambhunath De, Guardian Member, School Selection Committee, and Vidhan Chandra Debra Teacher, Member, School Selection Committee. The gist of the complaint is that the selection committee has been constituted with an assistant teacher, gadget teacher, as teacher representative, that is Vidhan Chandra Debra, in place of vice principal teacher. On perusal of the guideline framed by the government, Vice Memo number so and so dated 6/6/2014, the state selection board has to take into consideration leadership skill, administrative ability, integrity, and governing personally. Furthermore, as per guideline issued by the Director of Secondary Education Assam, by memo number so and so dated 26/6/2016, the marks awarded in the leadership skill is 5, administrative ability is 5 marks, integrity and SCR is 5 marks, and there is no discrepancy in awarding marks. Now, considering the matter strictly, and state selection board do hereby recommend the name of Shankar Ranjan Pal for the post of principal National High Court. So at the same time, since Shankar Ranjan Pal has also been empaneled as a tier number 1 with Abdul Ranking, scored 11 marks out of 15 in respect of Abdul Hasib HS second system. Shankar Ranjan Pal has been recommended for the post of principal National HS School Lamding, and according to Abdul Haq is hereby recommended for the post of principal Abdul Hasif HS school Pujai. Now let it, now let that impugn the next upward. I am directed to inform you that the matter relating to selection and appointment to the post of Principal National HS School Lamding was discussed by so-and-so. The opinion given by the standing of so-and-so, the selection for the post of regular principal of National HS School Lamding took place on so-and-so in pursuance of the advertisement that is so-and-so. Rule 13 of Rule 2020 relate to the procedure of selection of principal of HS School. Rule 84 is the rule of 2020 relates to continuation of school selection committee constitution. The state authority for the purpose of selection issued OL dated 6/6/14 in conformity with the Rule 20. The Director of Secondary Education Assam also issued an order dated 23rd June 2016 laying down the criteria distribution of marks to be awarded to the candidate in the selection. In the instant case, the Honorable Court came to finding that the constitution of school selection committee was not in conformity with the oriented so-and-so. This is important. Issued in conformity with the Rule 23. In the school selection committee, instead of vice principal of PT teacher, one assistant graduate teacher was appointed as the teacher representative. Though there is no information regarding allotment, but such deviation in aspect of constitution of school selection committee vitiate the entire selection. Upon provision of the provision of the aforesaid rule and the OL and the direction passed by the Honorable High Court by judgment and order dated 14/3/2018, passed in revision number 1296/17, it is observed that the earlier process held on 14/12/16 for selection to the post of regular principal, national higher secondary school Lamding is vitiated as constitution of school selection committee was not in conformity with the provision of Rule 23. The concerned FC school selection committee may go fresh selection for the said post among those candidates who applied and participated earlier in complete compliance of the provision of rule, criteria, norms laid down through Office Memorandum dated 6/6/14 and order of the DSC Assam on so-and-so. Now it is directed the inspector of school shall constitute a new selection committee as per guideline and may go for fresh selection for the posts among those candidates who applied and participated earlier in compliance of the rule criteria down the way dated 6/6/14 and order of yet. In pursuance of their lordship of the direction, the school selection committee was constituted, which was settled in this present repetition. And as per direction of the chief honorable court, present repetition also appeared. I have annexed that mark, statement of mark in my affidavit of position. Affidavit five, affidavit five, affidavit amendment 2/2025. Annexure 1, page 55. That this is the data material lordship will find in the top of the right side of the page. Data material 23/6/2019 and the petitioner is that CL number 4. Pankor Rangan Paul. After as per OM this selection of the considered and he secured third the black problem. Ranked. Was the third appellate candidate.
So now the one and two have already been retired.
Retired. Now whether the now issue whether after publication of the select list there is no after coming to FRBM Act lordship there must be one selection against one post lordship. Whether the first selected candidate can acquire any right. This is also one aspect. Second thing, lordship, as now government.
No, select list has.
When
not-
the
only a
that
panel.
FRBM Act was enacted?
Rule FRBM 2005 lordship, it was rule came into 2010.
10.
FRBM.
Lordship, under the rules, Lordship, the select list is only to be prepared by the state selection board, not by the school selection committee. School selection committee is only to forward a panel, Lordship, to the state selection board. So this is not a select list, this is a panel, Lordship.
Now the government.
Under the rules, there is provision with regard to this panel only in respect of the school selection committee, Lordship. The select list is yet to be prepared, Lordship.
Now, the page 52, Lordship, before that, Lordship, last paragraph number 7 of my application question.
Hmm.
Then the deponent back to state that the process of selection of regular principal of national higher secondary school Tamding was made by following Assam Secondary Education Provincial Election Certificate 2003 as amended 12. However, prior to finalization of the selection procedure, new rule, Assam Secondary Education Service Rule 2018 came into force. So far as matter is being submitted before the Honorable Court, and moreover, the process of selection of regular principal in other provincial higher secondary schools has been initiated as per new set of, that is Assam Secondary Education Provincial Election Rule 2018 as amended 21. Therefore, your deponent humbly prays before the Honorable Court to allow the deponent to withdraw the earlier selection process for the post of regular principal of National Higher Secondary School, Nagaon, had advertisement dated so and so, and further allow the deponent to initiate fresh process to appoint regular principal in National Higher Secondary School, Nagaon, as per existing service rule. This is the stand and the prayer before the Honorable Court. And the petitioner, he was just an MPNL candidate before the school selection committee also. He has not accrued any right to get him selected or to get him appointed also. So at this stage, my humble prayer to allow us.
No, Mr. Dotto, you see, selection process was initiated while the earlier set of rules and act were prevailing.
But it was not yet finalized. It's a very selection, just interview was held.
That may be finalized, Lordship. That is my prayer, Lordship.
Finalized,
because he won't be able to get any chance if any new selection is held, Lordship. He is going to retire in November, Lordship.
Had it been finalized in the year 2019, the petitioner would have not come, Lordship. The MPNL one candidate has come by a flux of time. He now can he, Lordship, get that benefit, Lordship. It is also by this is my way, Lordship, to by Paul. For litigation, it has kept on hold, Lordship. Otherwise, have finalized here and there, Lordship. Then
The question is, the process was initiated long back.
Yes, Lordship.
Under the old act and rules.
Lordship.
Now, in view of the enactment of the new act, whether the earlier process can be abandoned.
Lordship, in this case, there are two, three divergent views. But as per the clauses also, if any right put on the earlier appearance, that right to follow, Lordship. Even after repeal, Lordship. Yes, it is. There is no doubt, Lordship.
Then
whether he has got any right or not, Lordship.
no, he may not have the right to be appointed, but he has the right that the earlier selection process shall be taken to the logical conclusion.
And second thing, being appearing candidate, can he get claim to got finalized or to recommend him in view of that earlier first and second appearance considered candidate has retired? If now it is to be finalized, you will have to get give the appointment. He will get work of art, though he is not a selected candidate. It's a complex situation of the right.
No, since they have already retired, there is no question of appointing them now.
Appointing them. But it was the then Lordship in.
But if the selection process has to be carried out by the state selection board,
Lordship,
then let it be taken to the logical conclusion. Otherwise, what to do?
The provisions are otherwise perimeterial, Lordship. There is no difference between the new set of rules with regarding that selection to the post of principal.
Lordship, I try to at least, Lordship, in this matter, this situation, Lordship, in another day, Lordship.
Another day.
In another day, Lordship. I try to assist in how to solve this problem, Lordship. That is the right of the petitioner and the right of the state, Lordship. Because he has no indefeasible right to get.
No, that is well settled. He has no indivisible right.
No, Lordship.
But he has a right that the earlier selection process
Lordship.
has to be taken to its logical conclusion.
And that by flux of time, that selection is also.
That is also there. Anyway, let it be on next Monday. You come prepared then. Heard Mr. MP Sharma, learned counsel for the petitioner, Mr. Dotto, learned government advocate for the state respondent, Mr. Nandi for respondent number.
For the respondent number 5, but my name has been from the petitioner side.
Respondent number 5. And Mr. Ali for respondent number 10.
Lordship, in the other petition.
16. Okay. Okay.
I mean 10, my lord.
You are for 10. 10.
Respondent 5, my lord, in 16.
Okay. 5. And you? Respondent number 6. Respondent number 6. Heard in part? List the matter on Monday for further consideration.
Can it fix on 19, Lordship, when Thursday hearing that? On 16, 17, Lordship, I will.
Yes, Mr. Sharma.
Lordship.
Mr. Nandi, learned counsel for the respondent number so and so submits that his name has been reflected in the petitioner's side, though he has been representing respondent number 5. Justice shall do the needful in this regard.
Mobilize.
19. Thursday.
1 and Thursday.
17?
Please, Lordship. This is an appeal against the dismissal of the claim petition, Lordship. Appeal against the dismissal of the claim petition. Claim petition was dismissed on the ground of limitation. As the claim petition was filed after the period of expiry of the limitation period, Lordship. Impugn order at page 8, Lordship.
What wrong with that order?
Lordship.
You have failed to file the appeal.
Lordship.
No, failed to file the claim petition within the stipulated period.
The similar facts and circumstances, Lordship pass order. Lordship, considering the
Why
judgment
you
of
have failed to file the claim application in time?
Lordship, the claimant was not properly instructed by their counsel, Lordship. In the same line, Lordship may dispose of the claim petition, appeal.
But the question is whether any police case has been registered in connection with the accident.
Which case is there, Lordship?
Registered.
Registered, Lordship.
When the FIR was filed?
Lordship,
And who filed the FIR? No document has been enclosed.
the police case is there, Lordship.
Where?
Lordship, can you see at page 2, I have stated, Lordship, it is in the claim petition also. Reflected, Lordship.
You produce the FIR before this court will say.
Lordship, in the same line, Lordship, there is an order by you, Lordship.
No, that's all right. In that case, the FIR was perhaps filed within the time. To substantiate your claim, you have failed to enclose that FIR with this appeal.
Lordship.
You produce that document, we will see on next date.
Lordship,
After 1 week?
after 1 week, date may be fixed.
Okay.
Next week, Lordship.
Heard Mr. M. Talukdar, learned counsel for the appellant. This appeal under section 173 is directed against the order dated 3/1/2025 passed by the learned tribunal. Motor accident claim tribunal number 2 Hailakandi in MSC case number 31 of 2024. It is to be noted here that by impugn order dated 3/1/2025, the learned member Motor Accident Claim Tribunal number 2 Hailakandi has dismissed the claim petition. On the ground that the claim petition was filed after 1 year 6 days. So 1 year 6 days, which is barred by section 166 within bracket 3 of the Motor Vehicle Act 2019. Mr. Talukdar, learned counsel for the petitioner, the appellant submits that in CRP number 102 of 2024 by order dated 21/10/2024, this court was placed to allow the CRP directing the member Motor Accident Claim Tribunal, Amingao, to find out whether the investigating officer of Sanctuary PS has forwarded the accident information report to it or not. It or not. And if not, then it shall call for the same along with the FIR of the said case and treat the same as claim petition. And thereafter to proceed. Thereafter shall proceed to hear and dispose of the matter in accordance with law, and similar order may be passed here in this case also. But it appears that though in connection with the accident, Ratabari PS case number 20 of 2023 under section 279, T37, T38, T04A IPC has been registered. Yet a copy of the same has not been placed on record. Then accordingly, Mr. Talukdar is directed to bring on record the FIR of Ratabari PS case number so and so. And also the accident information report if the investigating officer has forwarded a copy of the same to the Motor Accident Claim Tribunal by filing an additional affidavit after 1 week. This is release the matter on next Monday.
Monday, Lordship. Here in this case, Lordship, we have challenged the quantum of compensation, Lordship. Monthly income considered on the lower side. Lordship, loss of consortium awarded on the lower side also, and interest awarded on the lower side, Lordship.
Heard Mr. Talukdar, learned counsel for the appellant. In this appeal, under section 173 of the MB Act, the appellant has challenged the judgment and order dated 26/5/2025 passed by the learned member, Motor Accident Claim Tribunal, Gwalpara, in MSC case number 126 of 2022. Notably, by the impugned judgment and award dated so and so, the learned tribunal has awarded is sum of rupees. What is the amount? Is sum of rupees 10,82,333 as the compensation with interest. Mr. Talukdar, learned counsel for the appellant submits that the compensation so awarded by the learned tribunal is in lower side. And while assessing the compensation, the learned tribunal has considered the monthly income of the deceased as rupees 6,000 only. And he also submits that the interest awarded by the learned tribunal is 7%, who is owed to have been 9% per annum from the date of filing of the claim petition.
Loss of constitutional also, Lordship, on the lower side.
The submission of Mr. Talukdar, learned counsel for the appellant, needs further consideration. At this stage, further consideration at this stage is to admit, issue notice to the respondents returnable in 4 weeks. Step be taken by speed post with AD and also by usual process within a week from today. Recessal call for the record from the learned tribunal. List the matter after 4 weeks.
Obligation.
Number 19.
Please, your lordship. I've come against an order for pay and governance.
Heard Mr. Argusami, learned counsel for the appellant. In this appeal under section 173 of the MBA, the appellant Go Digit General Insurance Company Limited has challenged the judgment and award dated 28/5/2025 passed by the learned additional member Motor Accident Claim Tribunal Tinsukia in MSC case number 42 of 2023, filed under section 166 of the MB Act. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees 6,05,000, being the compensation to the claimant of the MSC case number 42 of 2023. The respondent number 1 herein.
Lordship?
Respondent number 1.
Yes, Lordship. Yes or no?
Britanto Gogoi.
Britanto Gogoi.
Britanto Gogoi. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and award dated so and so. Admit. Issue notice to the respondents returnable in 4 weeks. Step be taken by registered post. Speed post with AD and also by usual process within a week from today. Recessal call for the record from the learned tribunal. List the matter after 4 weeks.
There's an application for stay.
So 50%?
Yes, sir, 70%.
Paribato?
So I don't for hearing number of problems. Number 21. May please your lordship. My lord, here in this case, the appellant as a plaintiff filed the suit challenging the sale deed of the defendant number 2 executed by defendant number 1. And the my lord, title suit was decreed. And we are against the reversal by the title appellate court. My lord, here in this case, my lord, the defendant number 2 has claimed to be bona fide purchaser, or my lord, he herself deposed that the defendant number defendant number 1 purchased the land from the plaintiff and then sell to defendant number 2. That was the plea of the defendant number 2, my lord. And she has deposed like that, my lord. Then, my lord, her duty was to demand for the sale deed, and also or to have asked the plaintiff about this sale. That has not been said, my lord. My lord, I want to draw your lordship attention, my lord, the evidence of the DW1 and DW2, my lord. Very specific. They said that the DW1 said that he purchased land from the plaintiff, and please, that sale deed is not produced before the court. The DW2 also stated that the DW1 has stated before her that the land was sold by the plaintiff to the DW1, then she come forward to purchase the land. But
Mr. Sigdar,
my lord,
you see subsection 3 to section 100 CPC.
My lord,
Subsection 3 to section 100 CPC.
section 100
CPC.
CPC. I have not brought the CPC, my lord.
You have not brought in.
My lord.
You see, your memo of appeal,
my lord,
the substantial question of law is not part of your memo of appeal.
My lord, I have given, my lord.
Where?
Keep filing. My lord, we have given, my lord, memo
Where?
of appeal, substantial question of law in the first page, I think.
First page.
Yes, my lord.
But this is
in
not
the
in
top
the
of
memo.
top of the memo
No,
of appeal,
it
my lord.
should be part of the memo of appeal. It is not part of the memo of appeal. You see,
My lord, maybe wrongly enclosed, my lord. But it is given, my lord. It is given, my lord.
No, this is not in proper format.
My lord, I have seen, my lord, the veteran, my lord, civil lawyer, be issuing the
Maybe you see the section, subsection 3.
My lord, even, my lord, in the
Maybe
hearing, my lord, a substantial question is
maybe
produced, my
maybe.
lord. If your lordship says that like that, my lord, then we have to shall precisely state the substantial question of law involved in the appeal, my lord. It is
Where you have mentioned here? In the memo of appeal, whether you have incorporated
it is said that in an appeal under the section, the memorandum of appeal shall precisely state the substantial question of law in the appeal. My lord.
Is it? In your appeal?
My lord, normally we give
No, normally usually forget about it. What the section states?
My lord, section says that appeal shall precisely state the substantial question of law involved in the appeal.
I will go by the provision of law.
My lord,
heard, Mr.
My lord,
Sigdar, learned counsel for the appellant. This second appeal is directed against the judgment and order dated 24/9/2025, passed by the learned civil judge, senior division, Nagaon, in title appeal number 1 of 2024. Peruse the memo of appeal.
My lord, in ground, my lord, we have said all these are substantial questions of law.
It appears that the substantial question of law is not stated in the memo of appeal as required by subsection 3 to section 100 CPC. Though Mr. Sigdar has enclosed a loose sheet suggesting substantial question of law in the memo of appeal. Along with the memo of appeal, under the given facts and circumstances, it is provided that Mr. Sigdar shall file amended memo of appeal incorporating the suggested substantial question of law in the same, and rest shall list the matter on next Tuesday.
My lord.
You file amended cost title, amended memo of appeal.
My lord.
My please, your lordship. I have filed one RSA regarding the impugnant judgment on the dated 7/11/2025. Big facts of the case that I have not taken any money from the plaintiff lordship. And the case is the judgment, the impugned judgment, it is partly allowed, but the interest portion is revised from 15% to 8%. And thereafter again from 8% per annum from the date of institution of the suit till the date of final disposal of the suit by the learned trial court, and thereafter 5% per annum till full realization of the decretal amount on 7/11/25. That's it. Finding no alternative, I have challenged the impugned.
No, that's all right, but where is the substantial question of law here?
Substantial questions of law, lordship, it is in not directly, but I have filed 10 grounds, lordship. If your lordship for a satisfaction, then I can also amend. I have not filed the substantial question separately, lordship.
But it should be in the memo
Yes,
of appeal.
lordship, yes, it should be.
By next Tuesday of next week. Same order.
118. In the meantime, I may be protected, lordship.
No, unless and until we admit the appeal, how can we
Lordship.
pass the order?
No, execution, they may start.
Maybe. We can give you the short date.
Lordship, then, not 13, then next Friday.
Friday.
Lordship.
May I please, your lordship? I'm extremely sorry, lordship. I was in family court, so I could not come at 10:30 for mentioning a matter. I beg to mention a MAC appeal for listing.
Where?
Next week, 19th.
Take a date for me.
With an IA.
Due to some technical reasons, lordship, the question for has not been constituted.
Not constituted. Okay. राति को कब डिस्क्लोज तो तुम देसन কি মান লাগে বলো হ্যাঁ ডিসক্লোজার Okay, we will admit that. We will call for the record. Okay. Thank you.
Okay.
24 and 25 for orders, orderly.
May I please, your lordship?
Education.
11, may I have a copy of the order, lordship?
11? Yes, yes. Okay.
And our name may be shown in the court research.
11 to কোনে তুমি লৈছিলা
Yes.
দেখাক এবাৰ কৈ দিব দেখাক কৈ দিব এবাৰ অ
Apply.
Lordship, in this case, Lordship, the NJ Khatuniar was, Lordship is going to appear, Lordship, NJ Khatuniar.
Pardon?
In this case, the engaged advocate NJ Khatuniar, Lordship, he just.
Okay, after some time.
Number 26. May it please. Earlier, my lord, this appeal has been dismissed for default, my lord, and subsequently in IA 950 of 2023, there has been restored. Though there are several miscases before that, my lord, for disposal. That was a substitution petition, which is setting aside abatement and delay condonation application, my lord. My lord, kindly peruse the IA 950, which was disposed of earlier. একদম তলত আছে তলত যোনটো আছে এইটো মিছ কেছ 950 950 950 20 950 It is order dated 21 to 25. That all the miscases as mentioned, my lord, 3702, 3703, 3704, miscase 22, 23, 24, 26. All has been, order has been passed, my lord.
So now what order is to be passed here?
My lord, in the substitution petition, that was also dismissed for default, my lord. We have filed an application for restoration, my lord. That is miscase 23 of 2023, my lord. Same, because say on the same ground, my lord, same region, wrong name has been reflected in the corpus.
Wait, please, Malad. Malad, I presently numbers 1A, 1B, the other was the only problem is my client has informed me that the evidence has also expired. I do not have the details in that regard. I suppose my learned friend may need to take instructions.
I'll take instruction, my lord, because I have, after my learned brother informed me, I tried to call up, my lord. His phone was switched off, my lord. Therefore, my lord, at least 2 weeks time maybe, because I have to write a letter, because the phone doesn't work, I think.
3 weeks.
3 weeks, ma'am, city লিখিব লাগিব, মোৰতো phone নকৰে. 3 weeks.
Okay. Heard Mr. Seladitto, learned counsel for the applicant, Mr. U. A does.
J does.
J does, learned counsel for the respondent.
A, B, and C. Respondent number 2A, B, and C.
2A, B, and C. And Mr.
Then Chaudhary.
And Chaudhary, learned counsel for the respondent number
1A.
1A. You? 1E to 1H. This interlocutory application is preferred for restoration of I number civil. IA civil number 1772 of 2022, which was dismissed for non-prosecution on 8/8/2022 by this court. During the course of deliberation, Mr. Chaudhary, learned counsel for the respondent number also submits that as per his information, the applicant herein suffered demise. At this is this, Mr. Seladitto submits that he may be granted 3 weeks time to obtain up to date instruction. We are allowed recessal is the matter after 3 weeks.
Obliged.
May please, Lordship. The last occasion's Lordship, the notice was issued in to the respond newly completed respondent number 3. Lordship, I think my friend will be appeared, Lordship. Now my friend is told me. I can represent Madam. It's the person, same Madam. Same person is Narayan Kaur. But I can represent him. And one more thing, Lordship, in the last occasions, I have filed an additional affidavit. And in the last order, Lordship, it is reflected that my additional affidavit will be considered in the next date.
You have filed your amended cause title?
Lordship.
When?
Yes, Lordship. On the last day, 8/1. 8/1/2026, Lordship. I have submitted it.
The newly implemented one is the contemnor number 3.
3, Lordship. 1 and 3 is name of same.
So what is where is the affidavit?
Sorry,
Where is the affidavit filed by you?
Lordship, that is page 100, Lordship.
What?
100. Sorry, Lordship, sorry. 123. Lordship, in this additional affidavit, I have just brought in the record that, Lordship, they have come now, Lordship, they rejected my claim on the basis of that the student enrollment was low. That's why my claim has been rejected, present impugned order, Lordship. So I have annexed the student attendance of the students in the year 1996 and 2008, where, Lordship, it is reflected that more students was there. So that's why, Your Honor, whatever their stand has been taken, that is prima facie illegal, Lordship. And then
Sir Khatonia, you have received the affidavit?
yes, last occasion. Last occasion already.
Any submission on that point?
But regarding this affidavit, I need to obtain this document. And one more thing, Lordship, whatever their stand has been taken, then another argument is that, Lordship, whatever their stand has been taken, that is prima facie also wrong. As because, Lordship, in the earlier occasions, one instruction is on the record in original read petitions, Lordship, where it is shown that teacher's pattern. But now there are given the teacher's patterns is different. And in the last occasions, what happened in the read petitions, Your Honor, once science teachers was there. In their report, it also mentions the one science teacher is there. And now, Lordship, what happened? The science teachers was appointed in my place. And they are saying the science teacher is still vacant. Kindly peruse this in the read petitions, Your Honor, the one report is there. On the basis of that report, my case was disposed of. And that's why this Honorable Court came into categorical finding that the present teachers is not an excess teachers. And her appointment was necessity. So once that finding is still there, Your Honor, so High Court Committee they can, and they may not be taken that step, whatever are whatever are reasons, Lordship, that's finding already given by this Honorable High Court.
Heard Mr. Hawk, learned counsel for the petitioner, and also heard Mr. N.J. Khatonier, learned counsel for the contender number 1, 2, and 3. Mr. I. Hawk, learned counsel for the petitioner, has filed one additional affidavit on 7th of January 2026, bringing on record the number of enrollment of student in the concerned school. And on the basis of the said affidavit, Mr. Hawk submits that the ground for rejection of the claim of the petitioner, in view of the additional affidavit filed by the petitioner and the documents enclosed therewith, are not at all justified. At this instance, Mr. Khatonier submits that he may be granted some time to obtain instruction. 1 week time, Mr. Khatonier. Pair allowed to list the matter on next Monday.
Next month.
Next Monday.
Next Monday, we should-
So as to enable Mr. Khatonier to obtain instruction in respect of the additional affidavit filed by the petitioner. List accordingly.
I levelized.
Item 27.
None appears for the petitioner on call. List the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
Item 28.
This I is for what purpose?
Continuation of delay, your lordship. There's a delay of
Continuation of
110
delay.
days. Yes, your lordship.
What is the ground for delay?
Your lordship, they have given the case to some other advocate. And that person advocate, he was suffer from some diseases, so he had to rush to Chennai. So due to his illness, he could not file the case on
In
time.
which
After he
paragraph of
returned-
your application you have
your-
mentioned
It
it?
is in para number 3.
Para number
3.
3.
Yes, your lordship.
Madam, have you gone through it?
Number 1, lordship.
Respondent number 1. 2 and 3 service not completed.
Yes.
Okay. No, in respect of 3 service completed, respondent number 3 personally received and signed the notice. What about respondent number 3? You want to take fresh step or?
I may be allowed to take a fresh step, your lordship.
Fresh step. Her miss, your good name, please?
A.G. Chaudhary, Anjana Gohai Chaudhary.
A.G. Chaudhary, learned counsel for the petitioner and no, applicant, and also heard Miss D.D. Barman, learned counsel for the respondent number one. Respondent number one. Office note dated 18/7/2024. No, 5/2/2026 indicates that notice to the respondent number 2 and 4 was issued on 28/8/2024. But the same return unserved with a postal remark in respect of respondent number 2 that not under Mukoksang, comma, while the respondent number 4 is totally illegible. In view of the above, the learned counsel for the applicant submits that she may be permitted to take fresh step upon respondent number 2 and 4. Pair allowed, step upon respondent number 2 and 4 be taken by speed post and also by usual process within a week from today. Rest shall list the matter after 4 weeks. After 4 weeks. Madam, you are representing respondent number 5 also. It is the same person.
Same instance company also.
It's Bowman for respondent number 1 and 5. So 2 and 4 you take fresh step after 4 weeks.
Service has been completed, my lord. Only a stay application is pending, my lord. And case has been already been admitted, my lord.
Admitted.
Already been admitted, my lord. Very admitted by the, my lord. Your
Service
order dated
completed.
11/11/24, my lord.
Service completed.
Service completed, my lord. Other side is-
Record received.
Yes.
IA is for?
I is for stay of the impugned judgment, my lord.
Okay. What is your stand?
Just if lordship is ready and the state order rule 41, sub rule 1.
So you have no objection in staying the
No, your lordship, that if your lordship is going to stay, then they have to deposit the security amount, your lordship.
what amount?
The decree order, your lordship, that they have to pay.
What is the amount?
That 1,50,000, your lordship.
1,50,000.
Yes, sir.
And out of which 50% has to be
Yes.
deposited.
My lord, there is a judgment I have gone through only on the principle, my lord. Though it's in first appeal, principle says, my lord, when the matter is admitted and if finds some serious civil consequences, the honorable can grant it stay in that case. But this case is, to be fair, my lord, it's a money decree. Suit was dismissed, appeal was allowed. Again, that being agreed, preferred a second appeal, which is now is pending for disposal. At present, my lord, with regard to the deposition of the security, it's a law, it's my lord, that also I can't run away. That too instruction is not yet. Execution case is pending, I feel. If you fail to deposit that amount, my lord, execution case may proceed. Your lordship can also pass disposing this application with a direction to the trial court, executing court. If they fail to deposit it the necessary amount, executing case can proceed, my lord.
Or your lordship can, for the time being, pass it over least after 4 weeks. In the meantime, I can get the instruction, my lord.
No, first you deposit the amount. What is the requirement of law?
Well, they will have to submit, my lord. But I will be depending on, my lord, this decision, my lord, where it says when the matter is admitted and is pending for the serious civil consequences, stay can be granted.
No, it is a money decree. What
It's a
civil
money decree. It's a
consequences
fair
will
submission,
ensue?
my lord. It's a fair submission, is it, my lord? It's a money decree.
Hmm.
Order 41
Then-
rule, if your lordship come to order 41, order 41, rule 5, my lord.
Hmm.
It says a stay by the appellate court, and appeal shall not operate as stay of proceeding under a decree or order appeal. If your lordship come to 5(3), my lord, that security has been given by the applicant for the due performance of such decree or any other ultimately binding upon him. It says decree, my lord, not a money decree or.
Mr. Das, you see,
If your lordship
earlier,
see, my
one,
lord.
you listen me. Earlier, one money decree was stayed by a coordinate bench of this court.
Yes, my lord.
The aggrieved party went to the Supreme Court.
Yes, ma'am.
Supreme Court come down heavily on the High Court
Yes.
for staying money decree without any security
And
deposit.
that's why my submission is, my lord, the lordship can dispose of this application with a direction to the execution to deposit, my lord, 10%, 15% as your lordship deem fit for the staying of the execution proceeding.
Hmm.
If you fail to deposit that amount, my lord, execution proceeding will follow.
No, is it the
Ultimately, my lord, this decree will have to be executed.
Hmm.
And for that, they'll have to go to the executing court.
Hmm.
My submission would be, my lord, this court will have no power to direct to deposit this amount. It will executing court they will have to be binding by the executing
This court has no power.
No power to say that, my lord, that you go and deposit, my lord. If I fail to deposit, execution procedure will follow, my lord. My prayer is to stay for the execution, my lord.
No. According to you, this court has no power.
No power to direct to deposit, my lord,
Hmm.
this amount.
Hmm.
If I fail to deposit, my lord, the executing proceeding will follow, my lord. Ultimately, it's a decree. Decree will have to be executed, my lord.
Hmm.
So, my lord, my prayer, it can be disposed of with a direction to the appellant to deposit 50%, 15% or 20%, whatever your lordship thinks fit. Failing, execution proceeding will proceed, my lord. Their purpose will be served, my lord.
No. Serving their purpose is not the.
Otherwise, my submission would be, my lord, I'll be paying for a stay. But to be fair enough, my lord, in a money decree, some portion will have to be deposited to the executing court. So, my lord, since I have got no instruction how much they are going to deposit or how much they will be able to deposit, so my submission would be, my lord.
No.
It
That
can be.
That is the discretion of the decree holder or the discretion of the appellate court.
My lord, this is the discretion of the appellate court, my lord.
Then
To deposit certain amount, my lord, it be a percentage wise, either 15 or 20% before the executing court. If you fail to do so, my lord, execution proceeding will follow.
Okay. Yes. What is your submission?
There is a Supreme Court judgment as well, which I can provide your lordship. But there is a may I, your lordship? But lordship in paragraph in para 2.
Execution to follow, execute করিনি, decree will have to be executed. Okay. Ajay, para 4, my lord. Para 4. It says a part of the money decree, my lord. Your lordship can decide the part of the money decree to how much percentage.
Okay. We will pass a necessary order in this IA, and the RSA we will list it for hearing. Heard Mr. Das, learned counsel for the appellant, and Miss learned counsel for the respondent. Mr. Das submits that in this appeal, service has already been completed and the record has also been received from the learned trial court and also from the first appellate court, and the matter is ready for hearing. Accordingly, it is provided that this is a list the matter for hearing in usual course. Okay, I.
31.
May I please, your lordship. Lordship, as per office note dated 2/9/2025, lordship, TCR not received, lordship, and no step has been taken. Lordship, in fact, they have appeared, lordship, already appeared.
You have all the respondents.
We have got a creator, your lordship.
All respondents. All respondents.
All respondent, your lordship. Yes, your
Pardon?
lordship.
All the respondents. Record has been received,
No, lordship.
not received.
Not received.
Record was called for or not called for?
All for lordship.
Called for. Notice here has been received. 2 September. Okay. Heard, Mr.
A Kalam.
Learned counsel for the appellant, and also heard Miss FN Jamat, learned counsel for all the respondents. All the respondents. Office note dated 2/9/2025 indicates that trial court record has not yet been received. Accordingly, it is provided that registrar shall issue urgent reminder to the learned trial court for transmitting the record without further delay. Registrar shall list the matter after 2 weeks. After 2 weeks.
Obliged.
32.
May it please your lordship, TCR has been received in this case. And
TCR received.
Received, lordship.
Service completed.
Lordship, matter has been admitted also, it may be posted for your
Already admitted.
lordship.
Okay. Heard Miss,
As to the lordship.
learned counsel for the appellant, and Miss Sharma for the respondent. Respondent, it is submitted at the bar that the matter is ready for hearing, and the trial court record has also been received. In view of above, it is provided that registrar shall list the matter for hearing in usual course.
Kindly.
Usual course, registrar will fix the date. It is of 2025 matter.
Item 33.
Obliged, lordship.
May I please, your lordship. Lordship, the petitioner is the tenant. The petitioner before your lordship is the tenant.
Okay.
A suit was filed for his eviction. And bona fide requirement on the ground of default and bona fide requirement. The suit was decreed. The petitioner filed an appeal That was also dismissed. Against that dismissal, the petitioner is before your lordship.
It has not been admitted.
Lordship, this is CRP at the stage of motion stage, notice was issued and their name has been shown, reflected in the cause list. On the last week, we mentioned the matter before because execution proceeding is going on before the lower court. It came before this honorable court on the last Friday. But since they have, although their name is reflected in the respondent's name is reflected in the cause list, but they did not turn up. And today also they have not turned up, although they have filed wakalat number, their name is reflected. Lordship, the issue is that tomorrow is the date fixed for deposit of police challan for police assistant for execution. And I am 65 years old. Lordship, I have been in the suit premises since last 30 years. And I have all parents to look after. I'm 65 years old. So this is my difficulty. Okay.
Itu na, Barbara. Itu Parna Barbara. Contact number আছে নি? Itu. Let the court master to contact the council. Wait for some time. Lord, he will contact.
May I please, your lordship? Lordship, as per the last office note, the service was is have returned because of incomplete, insufficient address, the note. Lordship, and if your honor peruses the last order passed by this honorable court, my interim pay was to be considered today. This is basically a transfer application of a matrimonial dispute.
No, here it is mentioned that interim pair will be considered on a returnable debt. Returnable debt notice could not be served.
Note. Lordship, the address which has been provided by the wife, in that address only we have taken steps, but it comes as unserved. Because the address, your lordship.
Insufficient address.
Yes.
The postal authority.
Yes, I take your lordship to their application before the family court, which is at page number 72. Residing at Lakmipat, Apigaon, Gauhati, with phone number. My prayer is to transfer the proceeding from family court Gauhati to Morigaon, where is the permanent resident of the wife. There are ancillary proceedings also which has been filed for restitution of conjugal right in the court of Morigaon, where their wife has filed an application and she have appeared there in Morigaon. But she have filed the dissolution application before the family court Gauhati.
So the petitioner is staying at Morigaon.
Yes. It's a permanent resident is in Morigaon, but she has shown to be staying in Lakmipat, Hatigaon. And have filed here the application.
The petitioner is the husband.
Petitioner is the husband.
He resides at Morigaon.
Yes, permanent resident at Morigaon.
Okay.
Wife
He
also.
resides at Gauhati also.
Yes, permanent resident of the wife is also Morigaon. But the wife has filed a dissolution case here. Actually, what happened, I'll just brief your lordship, a small fact. The wife have left the matrimonial home, and as such, the petitioner have filed an application under section 9 for restitution of conjugal rights. Thereafter, lordship, the wife did not appear and it proceeded ex parte against the wife, which your lordship will find at page number 38.
But
So
Mr. Counsel, you see, unless you serve notice upon the petition, on the respondent,
Lordship,
We
till
cannot
returnable
go
to at
ahead
least stay the proceeding of the Gauhati proceeding in Kamrup Metro till next date. That's the only prayer. Let them appear, let them file their objection in that. Because the proceeding in the Kamrup Metro is in continuous. And Lordship will see the wife have thereafter filed an application under
in
order
that proceeding, the other side entered appearance.
in Morigaon. In my
You
rest,
have appeared here.
I have entered appearance here, but because the last date was fixed on 17/1 and the matter did not get listed on it because of the cause list was it did not get listed. The matter was listed, but it did not reach.
Better you do one thing, you serve it by Dastimut then.
Lordship may fix a short date then. The next date is 23/2/26.
Heard, Mr.
F for ED, Lordship.
Learned counsel for the petitioner. Office note dated 4/2/2026 indicates that notice issued to the respondent number 2 respondent returned with a comment within inverted comma insufficient address RTS. The learned counsel for the petitioner submits that he may be allowed to effect service of notice upon the respondent by Dastimut. They are allowed. After effecting service upon the respondent by Dastimut, the petitioner shall file an affidavit before this court. This shall list the matter on resorted. 10 days.
Next date is 23/2. Any date before 20.
20.
Much open.
Interim care of the petitioner will be considered on returnable.
Much.
Yes.
On behalf of Arbora.
Yes.
In this case, we file our order now, 15/12/2025. If we sign to file our diploma.
But the execution case has already been filed. There is a pair for interim. You file your Kalatnama after 2 weeks or whatever you like, but we stay the proceeding then. Execution case. Okay, then we will list this matter on Wednesday. In the meantime, you obtain instruction.
Lordship, tomorrow is the date fixed. Till then,
Tomorrow.
Otherwise, we are pursuing.
Tomorrow they are not going to execute the decree. They will only deposit the.
They will deposit the challan for police protection, and tomorrow order will be passed, Lordship.
Maybe.
Already, because already that has been.
After tomorrow, we will consider your pair. In the meantime, let him obtain instruction.
Lordship, if possible, if my subject to tomorrow, because I don't know what. If some
No,
of
maybe day after tomorrow, if the court issue the warrant, then day after tomorrow we will consider your pair. In the meantime, let him obtain instruction. Heard, Mr.
G. Khandelia, Lordship.
G. Khandelia, learned counsel for the petitioner. And Mr.
K. Kashyap.
K. Kashyap, learned counsel, appearing on behalf of
Arbora.
Miss Arbora. Miss or Mr.
Mr. Arbora.
Mr. Arbora, learned counsel for the respondent. Mr. Kashyap submits that he may be granted some time to obtain instruction in respect of the interim pair of the petitioner. Pair allowed, rest shall list the matter on Wednesday.
Okay.
36.
May it please your lordship.
Look, as far as the service upon the respondents are concerned, my lord, there is a direction to take steps upon respondent number 7. Lordship may kindly see office note dated 3/2/26. AD not returned, my lord. What do you mean?
এগুলো তো অহা নাই। ঠিক, next question. Wait for some time.
Lordship, having regard to the ground in the appeal, my lord, name of respondent number 7 may be struck off, my lord.
Okay, that can also be done.
Yes.
Here for
Six.
6.
Otherwise, 1 to 6, my lord, they have appeared, my lord. Now 1 to
Okay.
5 is absent today.
Heard Mr. Kolita, learned counsel for the appellant.
Well,
And also heard Mr. Learned counsel for the respondent number 6. None appears for the respondent number 1 to 5. Office note dated 5/2/2026 indicates that 3/2/2026 indicates that notice issued to the respondent number 7. No, notice was issued to the respondent number 7 by speed post on 3/2/2026. And office note dated 5/2/2026 indicates that AD card as well as service report are awaited. However, Mr. Kolita, learned counsel for the appellant submits that in view of the grounds taken in the memo of appeal, the name of respondent number 7 may be struck off from the array of the respondents. In the appeal. Accordingly, taking note of the submission of Mr. Kolita, learned counsel for the appellant, it is provided that the name of respondent number 7 be struck off from the array of the respondents in MSC appeal number 583 of 2025 at the cost and risks of the appellant. Office note dated 5/2/2026 also indicates that LCR has not yet been received. Residential issue urgent reminder to the learned tribunal for transmitting the record. IA is for?
I is for stay, my lord. Similar order needs to be passed in that case also. My lord. Notice was sent to respondent number 7 as well. I is pending for disposal, my lord. I for stay, but since the
Yes,
claimants
any
are-
objection? For staying the judgment?
I have no objection. In fact, my
No
lord,
objection.
uh,
But you
I
have
beg
to
to interrupt,
deposit
Lordship.
50% of the amount.
I beg to interrupt, Lordship. Therefore, the owner of the vehicle, the claimants are absent today. So in their absence, may I think I should not pray for stay, my lord. If Lordship grants stay.
No, you deposit 50% of the amount before the registry of this court.
Lordship, can it be 20% because it's a case of CFP, my lord? Family pension schemes, yes, my lord. 20%, Lordship.
No, that can be adjusted later on also.
Lordship, then Lordship, we can deposit 50% and Lordship may direct to withdraw them 20%.
We'll see. Today they are not before this court.
Yes, my lord, that is.
Stay court. আগৰ অৰ্ডাৰখিনি একেই কৰি ল'ব পিছত হাৰ্ড অন দ্য interlocutory application for is that allowed subject however to depositing 50% of the awarded amount before the registry of the court. Okay. I dispose of
Much better.
In recessal list the MSC appeal after 4 weeks.
But
No parting in parting.
37. May please, your lordship. Lordship, here we have filed one IA under order for 41 rule 27 of CPC lordship in the RFA. For lordship, for making a contract agreement to be a part of court record lordship. Because lordship, during the evidence test of the suit lordship, we could not file by applying the due diligence also, we could not file the contract agreement as a part of a documentary evidence, and that is our backbone lordship. Because without the contract agreement, we cannot claim anything. Basically, the case is out of a money suit. So accordingly, lordship, we have filed this IA in the RFA. And on the last date also, this matter came up, but the respondents said they could not appear. I think the senior counsel was not present.
No, Mr. Borwa, you say your pair in this application is not clear. What is your pair here?
In the IA,
Yes. It is not in the cost title, not in the pair person. Where you have mentioned it?
It is not and yes, it is paid before lordship to kindly admit this IA and be pleased to pass further and other orders as a lordship may. If lordship this IA gets admitted lordship, then lordship the contract agreement will become a part of the court record if I am not mistaken lordship.
No, that's all right. But where you have paid for?
For lordship for disposing of the IA.
No. Your in respect of your pair in this IA.
Lordship. Basically, the payer is in regard for admission of the lordship IA lordship to admit the IA, and lordship the IA is basically lordship for making the contract agreement part of the court record. That is the lordship. Lordship will file a para number 2 lordship.
No, if that is your pair, we can dispose of this IA.
100%. That is the reason the matter has come up to tell lordship. And in fact, lordship on the other date also.
No, he was submitting that it should be admitted. IA should be admitted. When your pair in the IA is also not clear. You see the cost title?
Same document was held by them because there is a arbitration clause. They did not able to take the meeting. They preferred money suit, and it is not the admitted lordship amount. Your lordship kindly have a look at the where in the title.
No, that's all right.
That's another issue, lordship, because arbitration plus we both has to come together, lordship. One party can pay.
No, lordship, I'm not on that. Lordship, your lordship kindly have a look at the.
No, Mr. Majumdar, now by filing this IA, he want to bring on record that contract agreement.
Lordship, that is true.
Let it be.
Lordship,
Let it be.
Yeah, it is not at the time stage. No effort was made. Neither any application was filed. He is to prove that learned court below rejected his he made a due diligence. There is no such application.
No, that's all, lordship.
And another aspect, lordship, even if lordship admitted, but whether His suite can be improved. Don't you kindly again look at it
No.
there? Yeah, that time.
No, today we are not going to dispose of the main appeal.
Listen,
Today we are going to dispose of this interlocutory application, allowing him to bring on record that contract agreement. Only that.
I got lordship point because if the matter, if the IA dispose of, then it goes. I got lordship point. I think that's what lordship is indicating, lordship. If I pay for dispose of the IA, then the contract agreement goes. It will not, whether it will become a part of the court.
No. Disposing of IA is allowing your
Then
pair.
that's also, that is my pair lordship, although it is not very specifically mentioned in the pair.
Heard Mr. C.K.S. Borua, learned counsel for the, you are for the CGC.
Yes, I am from Government of India lordship. Applicant and appellant.
Learned counsel for the Government of India. And also heard Mr. L.R. Mazumdar, learned counsel for the respondent, opposite party. This interlocutory application is preferred by the applicant under Order 41, Rule 27, which read with Section 151 CTC for allowing him to bring on record one contract agreement which is annexed with the application as annexary. As the same was not enclosed with the appeal being RFA number 32 of 2022. 22 or 22?
22 lordship.
22. Mr. Mazumdar, learned counsel for the respondent opposite party, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application is then allowed, allowing the applicant, permitting the applicant to bring on record the contract agreement being annexary of the application. Annexary of the application. In terms of above, this IA stands closed.
Possible, sir.
In RFA then, when can it be listed?
So any completed in the next month lordship.
Record has been received? Received. Heard Mr. Borua, learned counsel for the appellant, Mr. Mazumdar for the respondent. It is submitted that the matter is ready for hearing and the LCR has also been received. And accordingly, it is provided that recessal list the matter for hearing after
3 weeks lordship.
After 3 weeks.
May please your lordship.
Hmm.
This is a condonation of delay, lordship. 80 days of delay. Notice may be issued.
Heard Mr.
Espego.
S.
Espego.
Espego, learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 80 days in preferring connected appeal, MSC appeal, against such judgment and award dated 29/5/2025, passed by the learned member Motor Accident Claim Tribunal Barpeta in MSC case number 156 of 2019. Let notice be issued to the respondents, serve opposite parties, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Obligation.
May it please, your lordship. Lordship, by way of this interlocutory application, we have made a prayer. We have prayed for setting aside and or alteration or modification of the order dated 23/7/2025, my lord. If I may quickly take your lordship to the facts of this case. What had happened, my lord? This opposite party appellant had filed a suit that is title suit number 112 of 2015, my lord, with a prayer for declaration that the plaintiff is a tenant under the defendant permanent injunction, and that another declaration that the plaintiff shall not be dispossessed without following due process of law. In that suit, we are the defendant, we had filed a counterclaim along with the written statement, and eventually this suit was dismissed. My lord will find that Annexure B at page 19, my lord. This is the judgment and decree passed by the trial court, and the operative portion that my lord would find at page 39. The suit was dismissed and the counterclaim was decreed. With the this order, my lord, kindly turn to page 39, my lord.
Okay.
Then they had filed two appeals, my lord. One against the dismissal of counterclaim, that is at page, my lord.
Okay, Mr. Nath, you have received the copy of this IA?
This IA I have received.
You want to file objection, or we can here dispose of the matter today?
Give us 1 week time to respond to this IA. And the entire matter may be hard because they have taken a long time. I have also seen that they said that the RSA is not maintainable. So that is otherwise the RSA, it was long back it was admitted and lordship has granted, we have prayed for stay, lordship has granted stay. Now they said that as per law, RSA is not maintainable. So next Tuesday, kindly keep, we can finish. On 17th.
17th, 1 second.
Ready?
That can be.
17?
If it is not maintainable as per law, we will not file.
Because they have given an
No, no,
undertaking.
appeal has already been admitted.
It is a,
Yes,
so finally it can be disposed of one merit.
okay.
My lord, because they have also in the other round of litigation, my lord, in the civil revision petition, they have given an undertaking that they are going to vacate it, and in fact, before the executing court, they have filed an undertaking. We have enclosed the document also, my lord.
No,
Despite
no,
that,
giving an undertaking cannot be the law point, no?
that was disposed
Cannot
of,
be the substantial question of law.
my lord, because of the fact that I'm not going to argue the matter on merit today. Only one submission is that under section 8 of the Assam Urban Areas Rent Control Act, no second appeal lies, my lord. This has been decided by our High Court, my lord, on the basis of a full bench
Okay.
judgment.
Okay.
And only civil revision under section 115 CPC is maintainable, and in fact, they have exhausted that remedy.
They have filed civil revision petition
Yes.
earlier.
Earlier, yes, my lord.
In our
And-
everything has been annexed. Well, in fact, what I find in this case, at that point of time, the contracting council, they prepared two appeals, two title appeals. But in this suit, they have filed WS and they also filed my title. He filed WS and he filed counterclaim. The suit, well, ultimately against the counterclaim, he prepared one appeal. Against dismissal of suit, he filed another. Both appeals dismissed. So against the dismissal, two dismissal, he preferred one civil division, and on the other hand, he preferred a second appeal. Second appeal is this civil division petition, the CRP, that was dismissed. But in my IA, in fact, everything has been brought, everything is on record. Now this objection has been raised. So my humble submission is that this has come for the first time. Lordship may take up the entire matter on Tuesday next. Let me respond to this also, and then the entire matter can be disposed of.
Okay. No, but Mr. Nath, it is an admitted position that no second appeal lie against a judgment and decree passed under the urban area rent control.
In their objection, it has now they have taken the objection. That is why I have said that they have raised the question of maintainability of the appeal. If that is the position of law, that is why I have paid for Tuesday. I'll not argue further. Although even though my appeal is admitted, it is a question of law has been framed, law has admitted my appeal. If it is against the law, I'll not go further. On Tuesday law.
No, but whether you have pointed out to this court that this is second appeal against the urban area land control.
At that point of time, I was not there.
Okay.
I was not there. I entered in the matter, I entered in the matter in the month of July 25.
July.
July. It was filed in 24 and it was admitted in 24. And in fact, notice was issued and the respondent, plaintiff,
Okay.
they did not respond at all.
It was admitted in the year 24.
24.
Okay.
Notice was issued, I have seen the record. They also did not respond to this despite receipt of notice. And both parties contested they were contesting the civil revision petition. Second appeal was in fact pending. Admitted appeal was there. The plaintiff respondent, they did not respond to this second appeal. They could have
Okay,
appealed and they could have pointed out.
Then on 17.
17, my lord.
17.
Against the law, I'll not do further. Let me just go.
No, there are several decisions of the Supreme Court. Heard, Mr.
GJ Soike, my lord. GJ Soike.
G.J. Soikia, learned counsel for the applicant, and Mr. D. Nath, learned counsel for the respondent opposite party. This interlocutory application is preferred by the applicant for vacating 10 stroke or for modification of the order dated 23rd 7 2025 passed by this court in I number 2267 of 2025 arising out of RSN number 119/2024. Mr. Nath, learned counsel for the respondent opposite party submits that this IA may be heard along with RFA number 119 of 2024 on 17th of February. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that registrar lists the matter on 17th, on which an endeavor will be made to finally hear and dispose of IA number 308 of 2026 and also the RSN number 119 of 2024.
Deeply
Okay.
okay.
I am for the opposite party appellant. I'm the opposite party appellant.
Opposite party.
Yes.
Sorry.